free Kyle. We have John Pierce, lead attorney for Kyle Rittenhouse, and we have Kyle Rittenhouse direct from county jail. Guys, what would you like to say to the fans?
I just want to thank every single one of you from the bottom of my heart for the underlining support. It's just amazing. I want to thank all of you for the mail I've been receiving. It's been really helpful. Just want to let you all know that I'm going to be out of here soon, and stay strong, and I hope to see you guys soon.
And I want to say that this is 100% self-defense. If this is not self-defense for Kyle Rittenhouse under these circumstances, then no one can protect themselves, no one can protect their family, and no one can protect their country. This is a watershed moment in American history. A very bright line has been crossed. The right to self-defense is a God-given right, and we are not going to allow a prosecutor in Kenosha, Wisconsin, to take it away from Kyle Rittenhouse. Thank you so much for all the support.
So the first charge that we're going to see is the first-degree reckless homicide charge with the use of a dangerous weapon. And this goes over to this individual right here, Joseph Rosenbaum. So if you remember him, this was from this part of the interaction where Kyle Rittenhouse is actually being chased down by Joseph Rosenbaum. So this is him right here. This photograph comes from a different picture of the evening where he was basically getting in somebody else's face and saying, why don't you shoot me? You want to shoot somebody, shoot me type of language. That was earlier in the evening. And then, essentially he was being provocative. From what we were able to see, this is a mugshot that I was able to find from him. Don't have any other, sort of flattering pictures that I was able to come across. Otherwise, I would have included one just for the sake of balance. But we have a mugshot, and then we have a picture from him earlier in the night, and then we see him here sort of being chased away. So they're saying that Kyle actually did recklessly cause the death of him under the circumstances, showing an utter disregard for human life, contrary to the statutes. Now, I'm not going to spend a lot of time on the statutes today on this show. I spent a long time yesterday or in the previous video really detailing the statutes, spent about 45 minutes going through every single one of them. So we're not going to do that again. I'm going to presume that you watched that video. You're up to speed on that. And so we're just going to read the complaint and the probable cause statement because, like I said, this is something that is written, in my opinion, so kind of one-sided that there's only really one logical conclusion that we can come to, and we will get there. So that was count one. Count one goes, it's basically the victim of that count is Joseph Rosenbaum, which is this individual right here. All right. So we have him here. Count number two, complaint number two, is going to involve the chief video director for the Daily Caller. This is Richard McGinnis. This is his photograph right here from his Twitter account. If you want to follow him, I actually have his Twitter handle later in the presentation here today, and so you can follow him if you'd like. But he is the victim of first-degree recklessly endangering the safety, his safety, and we're going to dive into why they included him on this complaint. Why is he the victim of a crime? He wasn't actually shot or anything. If you remember, this is him. When Rosenbaum was shot, McGinnis actually goes over there and takes his shirt off, and he's trying to heal, or kind of nurture or save him, help him with his wounds. And why is there we go. He's trying to help him with the bullet wounds. Now, we're going to learn later that he was shot multiple times, and sort of the efforts of McGinnis don't really do much of anything. He shot multiple times, so he was going to die. But he is the stated victim of this crime, and so it's important to recognize that because we're going to hear a lot of statements from him. He really is the only witness in this entire case. We're going to see the other witnesses that they talk to. There really isn't anybody else. This guy is the only sort of independent witness. The other people, three of them were shot. Two of them died. One of them had a bullet wound in his elbow. We're going to get to all of them, but they are not actual witnesses to what happened, at least in the first part of the incident. So we're going to spend a lot of time talking about McGinnis's statements. And the third complaint, the third count of the criminal charge, is going to be because of the death of Anthony Huber. Now, Anthony Huber is here. We can see this. This is his photograph right here. It was also the same guy we see here. So he was approaching Kyle Rittenhouse and was hitting him actually with the skateboard. Because he was shot in this altercation and he died, they're charging Kyle with first-degree intentional homicide, use of a dangerous weapon, because he did cause the death and he did intend to kill that person against these two violations. So that's going to be count 3. We move on to count 4, and this is going to be the other individual who was shot in the shoulder or in the elbow, and his name is Gage Grosskreutz. And this is who he is. Let me get rid of myself there. We've got Gage Grosskreutz, who was this individual here, who, over here, he's running up to Kyle as he's on the ground. We're going to see when we continue forward that Kyle actually sort of sits up and fires around. It hits him in his right elbow. You can see him right here. Now you can see in both of these photographs, he's got a gun right there. He's got a handgun physically on him. And then here, when he's nurturing his wound, I covered it with a blue circle here because it's really, really graphic. It's really gruesome, actually. And YouTube gave us an age restriction on one of our other videos for showing stuff like that. So I learned my lesson, not going to do that anymore. But he has a handgun here as well. He's also got a criminal record. That doesn't really matter here. But this is the fourth, it's attempted first-degree intentional homicide. So that's what they are doing on that one. The fifth count is going to be against an unknown person. So we don't even know who this individual is, but you can see him here from the video footage. He's literally jump kicking Kyle Rittenhouse right essentially in the head. And they're going to charge Kyle with attempting to basically fire at him, which is a reckless endangerment. It's endangering his safety. And so you can see that this unknown individual, we don't know who that is going to be the victim in count 5. We move on and we've got count 6, which is going to be the possession of a dangerous weapon by a person under 18. This one really is sort of the most uninteresting to analyze. My understanding is, I haven't taken a deep dive into the statutes, but that it's technically illegal for somebody who's under the age of 18 to openly carry a firearm. However, I have read that there are some exceptions to that rule if it is a rifle or sort of a long-barreled firearm that doesn't have any modifications to it. So, if that's the case, there may be an exclusion to this. This is the least interesting charge in my mind, at least in terms of criminal liability. If he's convicted of this thing, okay, what does he do? He goes to prison for 9 months. I really don't think that's going to happen, but if it did, that's a lot better of an outcome for Kyle than life in prison for several different murders, which is where it looks like they're trying to go. Now, there are some other interesting things about that particular charge, because if there are some arguments to be made based on the video that I did previously. When we analyze the statutes, there are some pressure relief valves that if a person is being charged with a crime and they want to exercise the self-defense privilege, they can't do that if they were breaking the law. In other words, you can't break the law and then suddenly claim self-defense when somebody responds to you breaking the law. I don't think that really is what happened here, but that is going to be something that the prosecutor's office may be able to break up. I don't think that they're going to, just based on the rest of the complaint. As we get there, you're going to see what I mean.
All right, guys, if you've been injured in a car accident, you have to check this out. So I just got this check from my attorney for $130,000. I'm going to go cash this immediately after this video, but I didn't even think I was going to qualify for anything. There wasn't a lot of damage to my car. I didn't think I was going to get anything for my injuries. And the way this works, and I put a link to this, there's this app. If you click beneath this video, there's a link to this app. But the way it works is you fill out some information about your injuries in your car accident, and immediately after you fill this out, it gives you an exact quote of how much money you can make for your case. And also it connects you with the best attorney in the area who's going to be able to get you this money. So guys, if you've been injured.
So let's dive into it. So the way that Wisconsin handles their criminal complaints is, it looks like, this is the first one I've ever read, but it looks like what they're doing is they're establishing the counts, and then they're including the probable cause statement right in the same document. I don't know if that's normal. I don't know. In Arizona, we don't do it that way. We have separate documents for that, and there's separate proceedings for that. But this may be just, they may have included it on that so that the public could see it, because this is such a high profile case. They're just saying, look, we're going to include the probable cause statement with the filing so that everybody can see it. This is where it starts. So let's dive into the meat and potatoes of the probable cause statement. So here, like I said, this is all clipped directly from the PDF. I just clipped it and threw it on a slide so that we can make sense of it and sort of break it down piece by piece. I'm going to read it, and then we'll do some quick analysis on it. All right, so the probable cause statement starts with, it says, your complainant spoke with these sergeants at the Kenosha Police Department who provided the following information. August 25th, we know curfew was imposed around 8 p.m. and they were located east of the I-94, Kenosha County, due to civil unrest. We all got that. August 25th, 11:45, shooting occurred. Here's what they're doing. They really need to establish location. So they need to explain where the shooting happened. In a previous video, I explained that it was right here. You can see here in the map, this is the corner of 63rd and Sheridan, where there is a car repair center. They're explaining where this happened. The reason why this is important is they have to establish jurisdiction. They have to establish some legal elements, and jurisdiction is one of them. So they are doing that. They're establishing that. They said that the man who was shot at this location was identified as Joseph Rosenbaum, transported to the local hospital, and died. Now, the curfew portion of this, everybody was violating it, right? So they didn't even charge him with that, with a curfew violation, because everybody was violating it. The cops knew it. I played it on a video previously. We saw that the cops actually even offered Kyle and some of the other people who were with him water bottles. You know, they knew they were there. They knew they were in violation of curfew, but nobody was enforcing it. So I really don't think that that is a big deal, or that opens the can. In other words, if he was, they're not going to claim that he was breaking the law, and therefore that invalidates his self-defense or any of those other doctrines. I don't see that happening. But technically they could, because he was in violation of the law, or they could at least try. Now, as a quick refresher, this is where both of the sort of groupings of the shootings took place. Really, in my opinion, I think this was one entire situation, one kind of continuous ordeal. The first shots happened here. We remember that Kyle was sort of running across. The shots happened here. He circled back around, popped out under the vehicle, and then he started running away this way. He gets chased, he gets knocked down. The shootings take place right about here, and then he runs up further towards the gas station convenience center up here, and that's when the cops kind of pass him by. And so, you know, it all happened pretty quickly. From the videos, it was a little bit hard to tell. We couldn't tell if it was really two separate incidents or not, but it all was looped together pretty quickly. So we had this part of the complaint. It goes on, and it says that in the course of investigating this incident, law enforcement reviewed the multiple videos, basically the same videos that we saw. They identified Kyle Rittenhouse. This is a very uninteresting portion of the complaint, because all they're doing is they're just establishing a couple things. One, they're identifying Kyle Rittenhouse. Two, they're identifying the location, the car source parking lot. They're explaining where Kyle's from. They're saying that they identified the gun, Smith & Wesson AR-15 style .223, and it holds 30 rounds, and they're basically, you know, listing out the parties, but there's not a whole lot to take away from this, not particularly interesting. The next paragraph is a little bit, right? So this is where we start to see that the probable cause statement, and to back up a little bit, the probable cause statement is written by the prosecutor's office, right? Why did they do this? Is this the police report? Is this the full police file? It's not. It's just a probable cause statement. So let's think about this. If you're charged with a crime, they need to have a reason to charge you with the crime. They can't just say, well, I don't like that person, so we're going to charge him with treason, right? That's what they did back in, the Middle Ages. A king would just say, yeah, I don't like that person, so we're going to charge him with 1,000,000 crimes. There's no basis for it, but because somebody had that power, they did that, and they were able to sort of use that as an excuse to, eliminate their enemies. Well, in America, we have to have a basis for filing criminal charges against somebody due to the wisdom of our founders and the wisdom of our justice system. And what they're doing here is they're establishing the basis for the charges. They need to explain why it's even probable that this actually happened. They need to establish some sort of facts in order to take the case forward. So that's all this is. There's going to be a lot more information that comes out. I'm going to explain what that is towards the end of this program here. But for our purposes, just kind of know that there's a lot of information here and a lot to dissect, but this is just kind of the tip of the iceberg, and this is just enough to get them to the next stage. All right, so enough of that. So let's go back to it. It says the video shows that as they cross the parking lot, Rosenbaum now appears to throw an object at the defendant. The object does not hit the defendant, and a second video shows, based on where the object landed, that it was a plastic bag. Rosenbaum appears to be unarmed for the duration of the video. A review of the second video shows that the defendant and Rosenbaum continue to move across the parking lot and approach the front of the black car parked in the lot. A loud bang is heard on the video, then a male shouts, "F you." Then Rosenbaum appears to continue to approach, and the defendant gets in near proximity to the defendant. And when 4 more loud bangs are heard, Rosenbaum then falls to the ground. So I read that a little wrong. Rosenbaum appears to continue to approach the defendant and gets in near proximity to the defendant before 4 more loud bangs are heard. All right, so here is Rosenbaum, right? And this is a photograph that I found somewhere, one of the news articles or on Twitter or something. And this looks like Rosenbaum, right? This is the same guy that we saw in previous photos. He has a red shirt. As he's running through this area, you can't really see here. You are seeing him in a red shirt. It looks like him. That is a bag he's holding earlier in the night. That is the bag that is on the ground. And so, you know, this part is interesting because they say that it was a plastic bag in the probable cause statement, but I would be curious did anybody pick that up and look in there, and what was in there, and why is he carrying this thing? You know, if you look at that closely, it looks like there's some weight to that bag. It looks like it's heavy. I can't imagine that this guy, brought his lunch over to a riot or a protest, whatever he thought he was joining. And it looked to me like, he threw it and it landed on the ground and it had some oomph to it. It actually kind of moved or stuck on the ground to me, it looked like what they were trying to do was, why is that doing that? They were trying to, actually use it as a weapon, almost like you would sort of swing it around and throw it. I forget what that weapon's called, but that's what it looked like to me. And there's also some interesting language here because it also says that, he's basically the aggressor here. Rosenbaum appears to continue to approach the defendant. He's approaching Kyle. He gets in near proximity to the defendant. He's throwing something at the defendant. All of this stuff is happening against Kyle, to Kyle. It's happening to him. It's not the other way around. So just from this language, now this is not my language, okay? I did not write that. This is from the prosecutor's office who is prosecuting Kyle Rittenhouse. They are explaining in this that this other guy was the one who appeared to continue to approach him. He gets in near proximity. He appears to throw an object. So why are they putting that in this criminal complaint if it's making it sound like Rosenbaum was the problem here, not Kyle? We're going to see a lot of that as we continue to move forward. So let's go back and we're going to see the next paragraph. It says that the defendant then circles behind the car and approaches Rosenbaum. Rosenbaum remains on the ground. McGinnis also approaches. McGinnis we're going to get to here briefly. McGinnis, if you don't remember, he's actually this guy who took his shirt off. He's the one who I spoke about in one of the earlier counts. This was the video editor for the Daily Caller. I think he previously used to work for the Mark Levin show. And, he's out there just capturing footage. Once he sees this shot go down, he takes his shirt off and he runs over there. McGinnis also approaches, removes his shirt, and attempts to render aid to Rosenbaum. The defendant appears to get on his cell phone, which he is right there. He's holding the phone to his head and place a call. Another male approaches. The defendant turns and begins to run away. As the defendant is running away, he can be heard on the phone saying, "I just killed somebody." We've got McGinnis here. We've got Rosenbaum, who's now on the ground. And then we've got Kyle, who actually, calls for help and then turns around. So the next paragraph is where we start to see what we learned from the interview from McGinnis. So Detective Seapress interviews McGinnis, and he indicates the following. And he says, before the shooting, McGinnis was interviewing the defendant. This is kind of nonsense, but it's interesting. The defendant told McGinnis that he was a trained medic. McGinnis stated that McGinnis, has handled many ARs and that the defendant was not handling his weapon very well. McGinnis said that as they were walking south, another armed male who appeared to be in his 30s joined them and said that they were there to protect the defendant. McGinnis stated that before the defendant reached the parking lot and ran across it, the defendant had moved from the middle of Sheridan Road to the sidewalk, and that is when McGinnis saw a male, Rosenbaum, which is this fellow, when he saw Rosenbaum initially try to engage the defendant. So McGinnis saw Emil Rosenbaum initially try to engage the defendant, which mirrors the previous paragraph that says that Rosenbaum was essentially kind of going after him. McGinnis stated that as the defendant was walking, Rosenbaum was trying to get closer to the defendant, When Rosenbaum advanced, the defendant did a juke move and started running. McGinnis stated that there were other people that were moving very quickly. He said that they were moving towards the defendant. He said that according to what he saw, the defendant was trying to evade the individuals. So again, we're seeing language from the prosecutor that makes it look like Kyle Rittenhouse is somebody who was trying to get away from this whole situation. He said that McGinnis says that he saw Rosenbaum initially try to engage the defendant. He said that Rosenbaum was trying to get closer to the defendant. The defendant, Kyle Rittenhouse, made a juke move, right? And in juke, you remember in football, you try to juke somebody out of their shorts and you try to get away from them. That's what a juke is. And then he started running. Others were moving towards the defendant, and the defendant was trying to evade those individuals. So not aggressive. He was fleeing. He was retreating. He was being pursued by a number of other people. And why is he being charged with a crime again? For this one? All right, well, let's move on. So McGinnis described the point where the defendant had reached the car. McGinnis described that the defendant had the gun in a low ready position, meaning that he had the gun raised but pointed downward. The butt of the gun would have been at an angle downwards from the shoulder. McGinnis stated that the defendant brought the gun up and that he stepped back, and he thinks the defendant fired 3 rounds in rapid succession. McGinnis said that when the first round went off, he thought it hit the pavement. McGinnis felt something on his leg. He first thought he was shot. He was wondering if he gotten shot. McGinnis was behind and then slightly to the right of Rosenbaum in the line of fire, and that's where he was when the defendant shot. So when you watch the video, this is a screen grab that I took. It's super blurry, but you can see it in motion. This is Rittenhouse. Remember, they run this way, and they kind of go back behind this black car here. Rittenhouse fires his weapon. Rosenbaum is hit. Rosenbaum falls, and McGinnis is right here. So he is, right? He's directly in the line of fire, it looks like. I mean, a couple shots here. He's sort of in between these two vehicles, so presumably, he is in the line of fire when the defendant shot. Now, I think that is accurate, right? I mean, he was there, which is why they're charging him with first-degree recklessly endangering another safety with the use of a dangerous weapon. And, is that something that's going to stick? We reviewed the statutes yesterday, and what we had talked about was the use of self-defense and what happens if that use of that force spills over into, and injures somebody else. Based on the video that I did, I think there's pretty good protections in place to say that some of that third-party liability, as long as it doesn't result in death. So if McGinnis would have been shot and killed, Kyle wouldn't have been excused for that. But because he wasn't actually shot, he wasn't injured at all, he was just in the general vicinity. Was any real harm done to him other than maybe some trauma of seeing somebody die in front of him and try to save their life? So obviously that's a traumatic thing. I'm not saying that what McGinnis went through, I don't want to downplay this incident at all. It was a very serious thing. But, was he shot? No. Was he killed? No. Was he injured? No. So there is some provisions in the Wisconsin statutes that we covered previously that I think would relieve him, speaking about Kyle, would relieve Kyle Rittenhouse of the criminal liability if the self-defense doctrine is appropriate. In other words, if he can claim self-defense, it's going to also apply to his, sort of including McGinnis in his circle. If he can say self-defense was appropriate, then the fact that he could have almost shot McGinnis isn't going to be a big deal. It's not even going to be, it's going to be covered within the self-defense doctrine. So we'll see where that goes. But I don't think that count 2 is even particularly strong on that. I mean, he was in the line of sight, but I think the self-defense doctrine is going to supersede that charge. And there were a couple interesting things to note on this one. McGinnis, he said he heard 3 rounds. If you remember, when we did the previous video about analyzing the audio in conjunction to the video, we did see that there was sort of a burst of 4 shots and then a burst of 3 shots. So we heard, sort of the pop, 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 pop. Yep. And then we heard 3 more pops. And the first 4 were the ones that were, Rosenbaum went down. And then the other 3, we really don't know what was going on with those just yet. There's been some, I've had some comments on this channel that some people are saying that that was a different weapon. Very well could have been. We remember that when we see Kyle at the very end of this ordeal get up and start walking to the police, it sounds like there's a lot of other gunfire going on in the background. So we know that there were other people shooting. We know that the first shot, from what we can tell, was from a handgun that was in the first part of that video. We saw that. We covered that in the previous video. But the point is there was a lot of bullets going off, and really nobody knew what was happening with that. We go back over to count one. This is the first-degree reckless use of a dangerous weapon homicide, right? So the complaint goes on. It says McGinnis stated that the first round went into the ground, and when the second shot went off, the defendant actually had the gun aimed at Rosenbaum. So he had it down, and then he fired one into the ground and then put it up towards Rosenbaum. McGinnis stated he did not hear the two exchange any words. McGinnis said that the unarmed guy, Rosenbaum, was trying to get the defendant's gun. Again, another aggressive maneuver from Rosenbaum that is backed up by McGinnis. He's saying that the other guy was the aggressor and trying to take his gun. And this is just connecting the dots. He was approaching him as he was running. He threw a bag at him. And then as the altercation proceeded, Rosenbaum did not back off. Rosenbaum kept moving forward and actually even tried to take his gun. McGinnis demonstrated by extending both of his hands in a quick grabbing motion. So he kind of, said he was going like this and pulled the gun towards him. And he tried to reach for the defendant's gun. Detective indicates that he asked McGinnis if Rosenbaum had his hands on the gun when the defendant shot. McGinnis said that he definitely made a motion that he was trying to grab the barrel of the gun. McGinnis stated that the defendant pulled it away and then raised it. So Kyle pulled it away and raised it. McGinnis stated that right as they came together, so right as they came, boom, and connected, then the defendant fired. McGinnis said that when Rosenbaum was shot, he leaned forward towards the defendant. And then he stated that after the defendant shot, he ran backwards towards the hospital, which is back over towards Sheridan Street, and then it sort of looped around like we saw. McGinnis stayed and turned his attention to Rosenbaum, stated he had heard other shots shortly thereafter. So a couple points on this, right? One is McGinnis is just confirming that Rosenbaum was really trying to be aggressive and taking this gun. He was following him, and he was grabbing at literally the barrel of the gun. And then Kyle Rittenhouse actually waited until right as they came together before he pulled the trigger, which is what ended up shooting Rosenbaum a number of different times. So again, is that Kyle Rittenhouse being the aggressor in this case? From McGinnis's own statements, it does not sound like it. It continues. We're going to move on into the next paragraph. The third video that we see that your complainant reviewed. So the prosecutor is saying, I reviewed the third video. It shows the defendant running northbound on Sheridan Road. So this is the second grouping that we had spoken about, right? We saw the first two videos, which show two angles of the first shots. Then we see one video of the second group of shots. Running northbound on Sheridan Road after he had shot Rosenbaum, the street and the sidewalk are full of people, and that is not an understatement. There's a lot of them. A group of several people begin running northbound on Sheridan Road behind the defendant. A person can be heard yelling what sounds like, beat him up. Another person can be heard yelling what sounds like, hey, he shot him. Your complainant reviewed a fourth video that showed a different angle of the defendant running northbound. In this video, a person can be heard yelling, get him, get that dude. Then a male in a light-colored top runs towards the defendant and appears to swing at the defendant with his right arm. This swing makes contact, and you can see that right here, with the defendant, with Kyle, knocking his hat off. And you can see that, right? There's his hat literally coming off. He's got his gun in his hand here. Here's the guy in the white shirt that's swinging at him. The swing makes contact, knocking his hat off. The defendant continues to run northbound. On the video, a male can be heard saying something to the effect of, what'd he do? And another male can be heard responding something to the effect of, just shot someone. The male then can be heard yelling, get his ass. The defendant then trips and falls to the ground. So here we've got a number of different threats. We've got multiple people that we can hear from multiple angles. And if we can hear it, presumably Kyle can hear it. And so he knows that there's a mob of people who are sort of enveloping him, and they're chasing him down the street. And we reviewed the video ad nauseum. I don't think we need to do it again. But we've seen he's really getting chased down by a lot of people who are screaming at him, get that dude. That's a quote. Get his ass. That's a quote. Beat him up. That's a quote. Those are all on the videos. So we want to ask ourselves, if we were in that position, or any person was in that position, what would they think? You've got multiple people making those claims against them. What are they supposed to believe? That's going to be important, because self-defense is going to be based on what a reasonable person would do sort of in that situation. We're going to get to that statute. We're going to talk about it again briefly. The complainant moves on. He says, or she says, as the defendant is on the ground, let me swap over here. As the defendant is on the ground, an unidentified male wearing a dark colored top and light colored pants jumps over the defendant. So that's this individual right here. So this is part of the complaint that is detailing what happened in count 5. Remember, in count 5, I explained that it was an unknown person. It was this person here. We didn't really know who it was, but they're still going to be charging Kyle with a crime as a result of firing at this person. He did not hit him, but he fired at him. So they're going to charge him with a crime for that. Now, we see here that he jumps over the defendant. Based on the sounds of the gunshots on the video and the positioning of the defendant's gun, it appears that he fires 2 shots in quick succession at this person. That person was not hit, and he runs away from the defendant. A second person, who was later identified as Anthony Huber, who is this individual right here, approaches the defendant, who is still on the ground on his back. Huber takes a skateboard in his right hand right here, and when Huber reaches the defendant makes it appear that he is reaching for the defendant's gun with his left hand as the skateboard makes contact with the defendant's left shoulder. So here, reaching for the gun as the skateboard is coming over his head and hitting Kyle. Huber appears to be trying to pull the gun away from the defendant. The defendant rolls on his left side, and as Huber appears to be trying to grab the gun, and the gun is pointed towards Huber's body, the defendant then takes one round, which can be fires one round, which can be heard on the video. Huber staggers away, taking several steps, then collapses to the ground. He subsequently died from the gunshot wound. And so we saw that at length, right? We saw him, Kyle, on the ground getting bombarded by people who were coming through. And let's take a look at the language again, right? We've got the skateboard makes contact with the defendant's left shoulder. So does that look like, it just makes contact? I love the language that these prosecutors use. This is, somebody just making contact. It's like the universe just brought the skateboard and Kyle together to become one. No, this guy, Anthony Huber, was attacking him with his skateboard as he was trying to pull his gun away. That language is way too light, in my opinion. You can see here from the video, a clip from the video itself, that he is getting struck over the head. He's got multiple people who we just heard were yelling things like, get his ass, get to him, get that dude, beat him up. And now he's getting hit over the head. He just got kicked in the head, and he's just getting hit over the head with somebody else's skateboard, who's also trying to take his gun away from him. So this is where we see count 3. Count 3 is going to be the first-degree intentional homicide, use of a dangerous weapon. Once again, that is saying that, yes, Kyle did intend to actually shoot him because he was being attacked. So we see here, we're acknowledging that a lot of this stuff had happened, that Kyle did in fact shoot people, but the prosecutor's office is again making every other person look like the aggressor. Why are they doing that? The complaint goes on. It says that after shooting Huber, the defendant moves to a seated position. So this is sort of a different angle here. You can see that this is Kyle Rittenhouse on the ground. This is Aaron Huber, who then is now falling to the ground. So it was this guy who hit him with the skateboard. He gets shot right literally in the heart, and then he collapses to the ground and he dies. This other individual, Gage Grosskreutz, is actually charging him as well. He's got a handgun in his possession, and he gets shot in the shoulder. So what does the complaint say? Let me get rid of myself. After shooting Huber, the defendant moves to a seated position and points his gun at a third male, later identified as Gage Grosskreutz, who had begun to approach the defendant. When the defendant shot Huber, Grosskreutz freezes and ducks and takes a step back. He puts his hands in the air. So he's sort of withdrawing for a bit, but then he moves towards the defendant, who aims his gun back at Grosskreutz and shoots him, firing one shot. He's shot in the right arm. He appears to be holding a handgun in his right hand when he was shot. He then runs southbound from the defendant, screaming for a medic, and the defendant gets up and starts walking northbound. Defendant then turns around, facing southbound while walking backwards northbound. with his firearm in the ready position, pointed towards the people in the roadway. And you can see Kyle right there. This other guy, so this is Gage Grosskreutz. He gets shot right here. And then he does an about face. He starts fleeing off. He's screaming, medic, medic, medic. And this other guy realizes that guy just got shot. This guy just got shot. He stops literally right in his tracks. I was going to say dead in his tracks, but that's not appropriate. We'll say immediately in his tracks, he stops and he puts his hands up, and then Kyle stands up and walks away. The remainder of the complaint is some detail stuff. We can see that it goes on. It says Dr. Kelly of the Milwaukee Medical Examiner's Office conducted an autopsy on Joseph Rosenbaum, who was the first person shot here in this scene, indicating that he had a gunshot wound to the right groin, fractured his pelvis, gunshot wound to the back, which perforated his right lung and liver, gunshot wound to the left hand, a superficial gunshot wound to his lateral left thigh, and a grazed gunshot wound to the right side of his forehead, which we actually did see on camera. And if you remember watching that, well, we saw him with the bullet wound grazed his head, but we didn't realize at that time that he had actually been in total been shot 5 times. Dr. Kelly also conducted an autopsy on Anthony Huber, who is this gentleman down here, indicating that Huber had a gunshot wound to his chest that perforated his heart, aorta, and pulmonary artery in his right lung. So literally right in the chest, and that's why he collapsed almost immediately. Complaint goes on, wraps up with saying that detective spoke with Dominic Black, who was the person on the receiving end of the phone call. So when Kyle, happened here, he picks up the phone, he calls somebody. That was Dominic Black. He's really the only other witness here, but he didn't see anything. He just accepted a phone call. So I'm not even really counting him. He stated that he received a phone call from his friend Kyle at 11:46. Defendant stated he shot someone. Detective Abraham Antamarian saw the defendant in person and identified him. So again, they needed to properly identify him based on the various videos that we saw. The final 2 paragraphs of the complaint, the attorney with this office, the Kenosha County District Attorney's Office, bases her knowledge of all of this information on. So remember when I was explaining that this was just the probable cause statement, there's going to be a lot more information that comes out. It's called discovery. So anytime there's a criminal case, and there's going to be a lot of stuff, right? You're going to have an autopsy report, police report, and all that. That's really what this is talking about. So this is what the prosecutor reviewed before filing this probable cause statement. It says, statements given to your complainant by all of these different officers and detectives. So there's going to be additional actual police reports that each one of these individuals type up. They'll type up a full report of everything they did, everything they saw, and that's all going to be part of the record, or it'll be part of the government's case. The statements from Dr. Kelly about the Milwaukee Medical Examiner's Office. So, of course, that's going to be the autopsy reports. We're going to have the videos that were included. We're going to have statements by the citizens. So, citizen informants, we got Richard McGinnis, who already gave his statement. We sort of went through that kind of at length here. And we've got Dominic Black. So we're going to have their written statements. Most of the time, these witnesses will actually write a statement out, and that'll be part of the government's files. And then what was interesting is that Kyle Rittenhouse actually spoke to the investigators, spoke to the detectives. So he made statements which were made contrary to his interests, which, you always hear this all the time, right? Never talk to the cops. Don't talk to the cops, because everything you say can and will be used against you. So I'm very curious what his statements are going to be. His statement should also be recorded. If it was a recorded interview, if he wrote a written statement, those are all going to be part of the record. Those are all going to be, admissions. Those are going to be things that he's saying, yeah, I did it. Yeah, I shot him. That was something that I did. And then it's going to be up to the defense to use self-defense as an affirmative defense. And so I want to wrap up with that. The final part of the complaint is signed by 2 people here. We've got Angelina Gabrielle, who's a deputy district attorney, and then we have Carly McNeil, who is probably another district attorney. She's the actual formal complainant. Nothing particularly interesting there, but that is the end of the complaint.
All right, guys, if you've been injured in a car accident, you have to check this out. So I just got this check from my attorney for $130,000. I'm going to go cash this immediately after this video, but I didn't even think I was going to qualify for anything. There wasn't a lot of damage to my car. I didn't think I was going to get anything for my injuries. And the way this works, and I put a link to this, there's this app. If you click beneath this video, there's a link to this app. But the way it works is you fill out some information about your injuries in your car accident, and immediately after.
All right, we are waiting for the stream to get cranking here. Looks like we are broadcasting on Periscope, so we're live on Twitter. We are now live on R&R Law Group. Looks like we're live on Facebook. The only thing we're waiting for is YouTube, and it looks like we're live there as well. Hello, everybody. Welcome back to another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney. My team and I, over the course of many years, we've helped thousands of people facing criminal charges go through the criminal justice system. And what we've decided to do now is actually sort of amplify what we're doing here. We're helping people through the process, but there are still some major issues throughout our criminal justice system that need to be addressed. And so what we have here is a show called Watching the Watchers, where that's exactly what we do. We're identifying misconduct. Hang on one second. We're identifying misconduct from police officers and prosecutors and politicians and basically anybody who's involved in the criminal justice system. We want to hold them accountable, because unfortunately what we see happen too often is a lot of these people are sort of masquerading as good guys. They're going through the criminal justice system and they're committing a lot of misconduct, a lot of malfeasance. And the best way to highlight this and the best way to root it out is by shining some sunlight on it, by notifying the general public about what is happening. Now, I'm getting some notifications that YouTube may not be working here, so let's take a quick moment and check. You're going to notice that things look a little bit different on the stream, and so as I'm sort of going through this introduction, we are going to be troubleshooting a couple things. You can see here that the background is certainly different. And I'm trying to identify why YouTube is not showing up. Is anybody on YouTube right now? It does look like we have some people on YouTube, but I'm not sure why it's not showing up on our main channel. Anyways, that's all right. We're going to keep going on with the show, but a couple things. So you can see that there's a new background here. We moved into a new office, and for the last week or so, I have been really trying to put together a new background and try to level up our YouTube production capabilities. And so what you see behind us is the new permanent studio. On the other side of this camera is a gigantic mess of cords and lights and cameras, and I'm still trying to figure it all out, but this is what we're working with today. So if there are any technical problems with this stream, I apologize in advance. Now, the other thing I want to share with you is something happened to me this past weekend that I don't usually like to talk about too much, but I had a birthday, and I'm not a big fan of birthdays. I kind of like to just be left alone a little bit on the birthdays and let them come and pass. Not a big celebration type of guy. And people in my life, they won't let me have that. So the office here actually threw a party on Monday to celebrate my birthday and another person's birthday and a 1-year anniversary. And so we had a little bit of a celebration, but I got a gift that I absolutely had to share with you on the show today because it's something I'm super proud of. So let me show you what I got. This came from a dear friend of mine here. She works here. Her name is Mrs. Harleen. She's awesome. And so they brought out gifts for me, and this is what I received. Let's take a look. Watching the Watchers. That's right. It's a t-shirt. So you can see here, it's got our logo, the Watching the Watchers logo right there. And what good would a shirt be without the hashtag on the back, Bad Popo? The Bad Popo hashtag. We call bad police officers bad popo. We call them bad prosecutors, and so on and so forth. So awesome gift. Now, once I end the show and I put this on, I do not anticipate that this ever leaves my body. But that is enough about the introduction. Let's dive into the actual program here. And so I want to start off with going through more Kyle Rittenhouse. This has been a story that I think is really one of the most paramount sort of our time as it comes to self-defense. And when we're talking about gun rights and the freedom to carry firearms with you and to protect your life, protect your property, there's a lot of issues at stake here. And I want to spend a little bit more time on it. Now, I don't want this channel to become the Kyle Rittenhouse channel, but there is some important things, that are happening here that I really want to spend a little bit of time on. So since last week, there have been some developments. Now, on this channel, we spent a lot of time covering a lot of different aspects of the Kyle Rittenhouse case. If you remember, we did a detailed analysis on the actual incident that night. We talked about the beginning, the first sequence of shots, the first shootings, the second sequence. We talked about the judge who was assigned to the case. We talked about the prosecutors who were assigned to the case. Today, we're going to talk about the defense attorneys who were assigned to the case, because if you've been following this, you know that both of the gentlemen who were involved in actually representing Kyle Rittenhouse are sort of in the middle of their own legal problems, and the same due diligence that we gave to the judge, the same due diligence we gave to the facts, the same that we gave to the prosecutors, we want to give to Kyle Rittenhouse's defense team, because he's going to be working with these guys for the foreseeable future, and we want to make sure he's got a good team in place. So we're going to get to that today. But before we do, let me give you an update on just what's going on with him. So last time we spoke, Kyle Rittenhouse was in Illinois. Now, he's still there. He has not been transferred yet back to Kenosha, Wisconsin. You remember this all took place in Kenosha, and he sort of at the end of the video sequence, he's running back towards the police. He has his hands up, and he's got a gun on his chest, and he's just sort of surrendering to the police. They drove right by him. Anyways, he left. He went back to Illinois. In Illinois, he had an extradition hearing, which means they were trying to talk about, what it's going to take to essentially send him back to Wisconsin so that he can have his day in court there. So right now he's in Illinois, and he had an extradition hearing that was scheduled previously, but it got moved. There was a continuance in the case, and so it's now rescheduled for September 25th. He'll be back in court on that day for his extradition hearing. Now, that's in Illinois. In Wisconsin, what happened was the judge there actually set a bond. So in other words, the way that this worked, when Kyle Rittenhouse left Wisconsin and went back over to Illinois, the court said, he's due in court. We have new criminal charges for him. He's not here. What are we going to do about that? So they issued what's called an arrest warrant for him. And they said, if you arrest him and bring him back into our custody, we are going to keep him in custody unless he posts a certain amount of money in order to get out of custody. Now, remember, this is very important because Kyle Rittenhouse is 17 years old. These types of cases, these criminal charges, literally take years and years and years to go through the justice system. So if Kyle Rittenhouse is in bond, in custody for the next 2 years, that's going to be a problem for him. It's a problem for any criminal defendant. It's a problem for anybody who goes through the justice system. We've represented many people who've been in these situations, who are currently in these situations. And from our perspective, it's a difficult thing for a person to endure, right? Of course, you, as a common sense person who's never been to jail, you can understand how difficult it could be to go from somebody who, like Kyle's situation, is 17. He's, presumably in school. He's a lifeguard. He's trying to, grow up essentially. And for the next year or 2 years or however long it takes to get him out of custody, his life is on hold. And it's not just on hold, it is being dramatically impeded by the criminal justice system. So this is one of the most critical parts of a case. We need to get him out of custody so that he can get back to life, get back to school, get back to a job, show the rest of the world that this is not somebody who is out running around with an AR-15 just trying to kill people, right? This was a kid who's trying to do something productive, got caught up in a bad situation, did what he thought he needed to do to protect his life and his well-being, and now he's being charged with a crime, and he's going through the justice system as a result. So the problem with being in custody for 2 years is that this is a process that is just sort of, I don't want to say it's designed to just deteriorate a person's willpower, but it absolutely does that. The system is sort of meant to just grind people into a pulp so that they have very little choice to do much fighting anymore, right? They're sort of incentivized to take a plea deal, close their case, because if they continue to fight, then they're going to continue to be in custody and they're going to continue to have this stuff over their head for a very long time. So a person in Kyle's position he's got a long road ahead of him. In other words, people, this process causes people to take plea deals that they may otherwise would never have taken, because they want some finality in their case. They want to get out of custody. They'll take anything. They'll just say, all right, look, yeah, I'll plead guilty to that. How much more time? 5 years? Fine, I'll take it. Because they're just tired of the process. And you have to think about the stress. Kyle's facing some charges that would put him in prison for the rest of his life if he's convicted of all of them. So to have that constantly weighing on your head, it's just incredibly burdensome. So getting Kyle out of custody is going to be a big focus. And there's a lot of work left to be done on that. He's in Illinois. He's going to get transferred back. And what we have seen thus far is the judge in the Wisconsin case. So once he does come back over to Wisconsin, the judge put a bond on his case of $2 million. So you can see that right here. This is a screen grab that I took today from the court's website itself, and you can see a couple items here. So this happened about 2 weeks ago, but Kyle, there was a warrant issued for his arrest. We've already seen that. It was issued by the judge Mary K. Wagner, who also set a bond of $2 million. Okay, $2 million is a significant bond, but is it really that different, or is it really that inappropriate for Kyle's case? Well, that's what we're going to dive into today. We're going to look at the rules for the Wisconsin statutes that will detail what is an appropriate bond and what is an inappropriate bond. So the judge in Kyle's case did say that it's a $2 million bond. That's a very high bond. I covered this last week, that there's another defendant, Crystal, who is also out of Kenosha, who is also being prosecuted by the same DA, who had I think it was a $1 million bond that was reduced down to $400,000. And we did sort of a case-by-case comparison on Crystal's case and Kyle's case, and we saw that they sort of didn't really match up. Why was she getting a $400,000 bond, but he was getting a $2 million bond? Hers originally started at 1, was dropped to $400,000, and Kyle's is still at 2. So we want to just go through the rules, right? What are the judges looking at? What are the prosecutors looking at? What are the defense attorneys looking at? And we can see if there are any arguments that may justify getting Kyle out of custody without posting that $2 million bond, right? Now, one other important thing to note, and this is a long sort of segue here, but it's important to note that this judge, Mary K. Wagner, so this judge who posted this bond here, it really hasn't seen anything yet, right? Doesn't know much about this case at all, other than what she saw from the charges that are going to be posted, or that were posted in the probable cause statement from the prosecutor's office. That's all the judge knows. And from what we've seen here, I looked through the more recent activity on the case, but I don't see a lot of activity. There was a proposed order that happened the day after the warrant was issued, and that's about it. So I really don't know if there has been any sort of movement from Kyle's defense team to file motions to modify their release conditions, or whether they've had any presentations to the Wisconsin court. We just don't know that yet, but we will soon enough. So my point is, Mary K. Wagner, the judge who issued this bond, is sort of probably flying in the dark, or supposed to be flying in the dark. Now, this judge is going to know everything that you see on the news and in the media, but in terms of the concrete evidence that is in front of this judge, they just haven't seen it yet, or probably have not seen it yet, which is why there may be some wiggle room on this bond once Kyle does get transferred from Illinois back to Wisconsin. All right, so now let's talk about the actual, what are the rules in Wisconsin? And they have some pretty good rules that I think are actually favorable to Kyle Rittenhouse's case, but he's not in Wisconsin yet. When he does get there, I think that there are some pretty good arguments that this bond should be reduced down, or there should be no bond, or there should be some other sort of limitations on his ability to be out of custody. And we're going to talk about that. But let's take a look first and foremost at the eligibility for release. So Kyle Rittenhouse is in custody. He's going to be transferred back to Wisconsin. What is a judge going to look at when they're determining whether or not to release him from custody? So here we go. This is from section 969.01 of the Wisconsin statutes, and here's what it says. It says, a defendant arrested for the criminal offense is eligible for release under reasonable conditions designed to assure his or her appearance in court, to protect future members of the community from serious bodily harm, or to prevent intimidation of witnesses. So that's a long way of saying there's 3 things that the court wants to consider when they're going to be releasing somebody from custody. 1, is he going to come back to court? Is Kyle Rittenhouse going to show up to court? They need him to show up to court. That's the primary purpose of these release conditions. It's to get him present and going through the process. Does anybody think that Kyle Rittenhouse is not going to go to court? Maybe some people do, but in my mind, that is kind of a no-brainer, right? He's going to go to court. He's a subject of national media attention. This guy is not going to slip under the radar. People are going to know where Kyle Rittenhouse is. The other issue that the court wants to discuss prior to releasing somebody is whether or not there's going to be any issues protecting members of society from Kyle Rittenhouse. So the second major facet is whether they can protect members of the community from serious bodily harm. And again, is this something that Kyle is going to go and shoot more people? This entire situation, in my mind and in our analysis, and it's not just mine, there are many other defense attorneys throughout the country who are saying this is clearly self-defense. So if he doesn't have a history of being proactive and going and finding people to shoot, then, and this is just purely a self-defense issue, that prong, I think, is pretty easily met. And then finally, the law itself says that we want to talk about identifying or protecting people, protecting against the intimidation of witnesses, right? So on this final last prong here, the intimidation of witnesses. Are we going to see that in this case? Is Kyle Rittenhouse going to intimidate any of these other people? I just don't see that, right? He's a 17-year-old kid. He's in a bad situation, and this is not something that that I think he's got, a gang, or he's got the resources that are going to go and really undermine other witness statements in this case. And quite frankly, there really aren't that many other statements. From the government's own probable cause statement, we had the two witnesses who two people died. We had the reporter who essentially, McGinnis, who was actually talking in the probable cause statement and making claims that, in my mind, actually backed up Kyle Rittenhouse's claim. We have an unnamed individual, and then the other victims are just the government. It's just, well, he was there and he shouldn't have been there is what the government is claiming. He shouldn't have had a gun or whatever, the basis of that misdemeanor charges, which really isn't that important in my mind. So that is, those are the three things that they're considering, and I think Kyle Rittenhouse has a strong case for all of those. Now, what's important to note in this statute also is that all right, we are waiting for the stream to get cranking here. Looks like we are broadcasting on Periscope, so we're live on Twitter. We are now live on R&R Law Group. Looks like we're live on Facebook. The only thing we're waiting for is YouTube, and it looks like we're live.
All right, guys, if you've been injured in a car accident, you have to check this out. So I just got this check from my attorney.
Did the judge in the George Floyd case just disqualify the prosecutor's office? The same prosecutor's office who's responsible for prosecuting the four cops who were responsible for killing George Floyd. Something interesting is happening. We learned on Friday that in Derek Chauvin's case, if you remember Derek Chauvin, he was the cop that had his knee on George Floyd's neck, the same one that we saw in the video, the same one that people were screaming at to get his knee off his neck because he was killing him. He was charged with murder. Now, his case is going through the court system. On Friday, September 11th, we had an omnibus hearing, which is sort of a big hearing where the court listens and hears and resolves a lot of things all at the same time. We had that hearing on Friday. We know a little bit more about what took place. Now, because this hearing happens behind closed doors and because it was done orally, a lot of this stuff happened right in the courtroom, and we don't know much about what happened other than what we can glean from the court record. So if you look up in Minnesota, if you look up their court records, you're going to see that you can find information that looks like this. This here is an actual screenshot from the records that we just looked up today on September 14th, and we can see some interesting stuff happen on Friday. So let's take a look. If we look up top here on 9/11, we're going to see that the omnibus hearing was held in front of Judicial Officer Peter Cahill, held on the record. There were a couple impositions. The court imposed some requirements on Derek Chauvin. Now, again, he's the cop who's responsible for putting his knee on George Floyd's neck, resulting in his death. Couple conditions here. Number one, he's got two different bail settings here. He's got one for $1.25 million with no conditions, and he's got bail or bond for $1 million with conditions. And so he's got some other limitations on his ability to leave. He can't, say, for example, he can't leave the state of Minnesota without court approval. He has to remain law-abiding. He has to sign a waiver of extradition. He needs to make all future court appearances and so on. So this is one of the things that the court resolved. They always do this. They set release conditions and they set bonds and they do a lot of other things. But something else must have happened here. Now, we can't see it from the minute entries, but we can see that the government filed a response today. Take a look. You can see down here on 9/14 that there was a new motion filed and an affidavit, and we have e-service. So that means that these motions were filed in the court and they were actually served on Derek Michael or Derek Michael's lawyers. These are presumably going to be ruled upon on 9/18, so in a few days' time, and what are we talking about, right? This motion was filed by the government, and what does it say? Well, it is surprisingly interesting. It actually is what's called a motion for reconsideration. So remember, in any criminal case, you've got three parties. You've got the criminal defendant, that's the person who's been charged with the crime. You have the prosecutor's office, they're the ones responsible for prosecuting the crime. And then you've got the judge. You've got the judge who's supposed to be the neutral arbiter between the two parties. Well, what we have going on here is something happened on Friday where the defense may have made a motion, or the judge made a motion of the judge's own accord, and the judge issued a ruling, and the ruling was adverse to the government. The ruling went against the prosecutor's office. And so in this motion, what we're talking about is the prosecutor's office asking the court to reconsider. It's called the state's notice of motion and motion for reconsideration. What are they asking the court to reconsider? Well, on Friday, presumably, the court entered an order prohibiting the participation of Michael O. Freeman and others from the case. So the court went through and they said, you're not allowed on this case anymore. You have been disqualified. That is our final order. And the prosecutor's office is coming back and saying, hold on. Wait a minute. We're going to ask you to reconsider. We don't want to be prohibited from participating in the case. And you may say, well, that's not that big of a deal, right? There's probably a lot of people who shouldn't be participating in this case, but not this guy. This guy, Michael O. Freeman, which the court is excluding, is in fact the main county attorney for Hennepin County, which is where George Floyd's case took place. So Michael O. Freeman is the lead prosecutor. This is the guy who's responsible for prosecuting a huge portion of crimes out of Hennepin County. He's the Hennepin County attorney, and he is sort of the chief prosecutor in this area of the law. Here is a little bit more information about this fellow, Michael Freeman. He is the elected Hennepin County attorney, served as the Hennepin County attorney for 14 years from 1991 through 1999, also again since 2007. And you may remember this guy. You may have seen him speak. He had a couple of sort of interesting press conferences where he would come out and be really angry and then sort of indignant that he had to charge these cops with crimes. And it was just kind of a weird thing, but he was on this case presumably because he is the county attorney. He got involved in it because he's so high up, and this is such a high profile type of crime that he got involved. So what the heck, why would he be disqualified from this thing? Well, something had to have happened. What are we talking about specifically? So here is from the government's motion. So again, this is the prosecutor's motion. They're filing this to the judge, and they're saying, Judge, we don't like what you did on Friday. Please reconsider. And again, because we don't know really exactly what happened in court on that Friday day, what we're going to do is we're going to glean more information from the government's own motion to the court, because they're going to be responding to what the court said. So let's take a look at what the motion says. It says here that they're asking the court to reconsider. They're citing some case law here out of Minnesota. The order that by the court's own order would have otherwise prohibited Hennepin County Attorney Michael Freeman, his deputy chief, Andrew Lefevre. We've got a managing assistant county attorney, Amy Sweezy. We've got senior assistant county attorney, Patrick Lofton. So all four of those people, which is going to be the chief, the county attorney, the head honcho, and his three sort of deputies, are all going to be disqualified from participating in the prosecution of this case. The court's ruling was premised exclusively on the finding that they violated the advocate witness rule, which we're going to talk about when they had a meeting with Hennepin County medical examiner, Dr. Andrew Baker. And they're also going to the court is saying that they are disqualified because this was something that was handled sloppily by their office. Look at this, double red line marks right there from yours truly, because you don't see this type of language in motions. They're saying that the judge is saying that these four attorneys violated the advocate witness rule because they were present in a meeting with Dr. Baker and there was no non-attorney witness present. That is sort of the crux of what the court is saying happened. So they're saying that this meeting took place, the court's upset about it, and therefore these four lawyers who were involved in these meetings are going to be disqualified. So that's sort of the high-level overview of what the government is asking the court to reconsider. Court said you're out. Government is saying, nope, let us back in. Please reconsider. So what is this rule that the court is talking about, this advocate witness rule? What does that actually mean? sort of a little bit of a difficult concept to grasp, but I'm going to try to lay it out as easily as I can. But let's look at the rule, the actual statute, the law, the rules that the government cites in their motion to the court. You're going to see here that it says the advocate witness rule provides that a prosecutor cannot be a courtroom advocate for the state and a witness in the same trial. One more time. A prosecutor cannot be a courtroom advocate, so that would be like a lawyer, for the state and a witness also in the same trial. It goes on, it says there's some long-standing rules, and it also says a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. A necessary witness. So what does this mean? So an example that I was thinking about prior to making this video is, let's say, for example, that I'm in a car with a friend of mine. My friend is driving the car, and I'm a criminal defense lawyer. I'm just your everyday guy making videos for YouTube. And my friend gets pulled over for a DUI. Well, I'm in the car with my friend. And so I'm a witness to everything that happened. I'm a witness to how much he had to drink before he got in the car, if anything. I'm a witness to how the cop pulled him over, what the basis for the traffic stop was. I'm a witness to the conversation that the cop had. I'm a witness to the field sobriety test. I'm a witness to all of those things. So if a defendant, if my friend came back into my office and said, listen, I know you were with me. You know this case better than everybody. By the way, I want you to represent me in court. That would cause a whole series of problems. You know, how can I ask questions of myself? How can I sort of set up myself to deliver testimony that's going to be a bombshell, you know, massively positive for my friend's case? That's what my incentive would be. And so it's hard to do a cross-examination in that type of situation. It's hard for the prosecutor to come and ask me questions because I'm the lawyer and I'm the witness. And it creates some perceptions of bias and there's all sorts of reasons why this is a bad idea. You want to keep people separate. Prosecutors should be separate from the witnesses, and the witnesses should be able to testify on their own independently of any undue influence from prosecutor's office or from defense attorneys or from cops or from anybody else. They should be unbiased and they should be authentic, and we should be able to trust them and understand that they are credible witnesses. So when an attorney sort of minces these lines, it's a problem. And so what does that have to do with George Floyd? It makes a lot of sense in the context that I just described it in, but what about in this particular case? And so let's go back through the timeline. I want to run through it briefly so you can recall what happened with George Floyd. Here we have on May 25th, 2020, George Floyd dies. His body was received by the medical examiner's office on that same day. So Hennepin County receives George Floyd's body on that day. The very next day, the Minnesota Bureau of Criminal Apprehension, otherwise known as the BCA, says that they're going to review with the HCAO, which is the Hennepin County Attorney's Office. So in other words, the BCA is going to confer with the HCAO, and they're going to assign these two attorneys who are going to be Mr. Sweezy, Mrs. Sweezy, and Mr. Lofton. Dr. Baker, who does the autopsy, then meets with the BCA, the FBI, and the same two prosecutors, and he reports his preliminary findings, but says that they're preliminary. They're missing some things. They're missing the toxicology reports and the video evidence. The next day, so 2 days later after George dies, Dr. Baker then meets with Freeman, who is the Maine County Attorney, meets with his subordinates, the Chief Deputy, Andrew Lefevre. We've got the Managing Assistant County Attorney, Amy Sweezy, and then we've got the Senior Assistant County Attorney, Patrick Lofton. So you've got 4 attorneys now who are all meeting with this Dr. Baker. And they're meeting very privately. The motion goes through a lot of detail to say that they limited this contact and they kept things very, very tight because they knew that the public was up in arms over this case, and rightfully so. And so they wanted to protect this information, and they were being very cautious about it. And so these 4 prosecutors, all of them very, very high up in the prosecutor's office, are meeting with Dr. Baker, and they're doing it in privately, and they're doing it without any other non-prosecutor witnesses. So it's just these 4 lawyers who are prosecutors and Mr. Baker. This is where the judge is having issues with it. the government's motion. Again, this is all facts that are based from the government's motion. The government drafted this. These facts come from their opinion. We don't have the defense's response to this. If they're going to be filing a response, we don't have any written orders from the court. All of this is coming directly out of the prosecutor's mouth. So take that for what it is. But we're going to be charitable, and we're just going to say that we're going to read this motion in the light most favorable to them. So we're going to do that, and we're going to say that we're going to take this for as true as we can take it. So Lofton, who is one of these prosecutors, then writes a memo. He says that Dr. Baker on the 27th told them the same things that he did on the 26th, but he gave us some more information about the prior injuries to Floyd and other times that he was in the hospital. Then on May 31st, Dr. Baker again has a video conference with Lofton and Sweezy. This time he discusses the toxicology reports that were done by an outside lab. And then finally, a couple days later on June 3rd, Lofton and Sweezy, they withdraw from the prosecution team entirely for unrelated reasons, and a new prosecutor is assigned. So these are really the problem dates: May 26th, May 27th, and May 31st. Those are the days that the Hennepin County Medical Examiner, Dr. Baker, is meeting with these four prosecutors. And so we don't know really what the judge's issues were here, other than sort of presuming the fact that this was kind of an unethical meeting, or they should not have had this meeting without a non-witness or a non-attorney witness present. The reason being is because they want to make sure that there's no undue influence going on here. They want to make sure that these four prosecutors are gathering information from Dr. Baker. They're not creating information with Dr. Baker. They're not having a conversation about this information. Oh, Dr. Baker, are you sure that it wasn't the drugs? Are you sure that it wasn't that fentanyl in there? Or maybe the fentanyl really doesn't matter. Or maybe it was more about, maybe he intended to kill him. Maybe there's more evidence of, could they be manipulating the conversation one way or another? Now, this is not saying that they did. Don't see any evidence on that here, other than the fact that the judge ruled against them. The judge listened to something in those oral arguments on Friday and decided that they all needed to be disqualified. Now, there is a lot of confusion about what the judge actually said, and the government admits that themselves. The government says in a footnote in their own motion that they really don't know exactly what the court did, and I can understand some of their arguments here. Let's take a look. The parameters of the court's oral ruling from the bench are not entirely clear. This is what the prosecutor says. The state certainly understood that the court's order prohibited the named attorneys from appearing as courtroom advocates, but the court's ruling also suggested that the named could not participate in the case beyond administrative duties. So what does that mean? Mr. Freeman was elected. That is the county attorney. He's responsible for overseeing the management of the cases. He has assumed all of this stuff. And basically what they're saying here is that if the court prohibits Hennepin County Attorney's Office from being involved in this case, that's a major problem with the separation of powers. Remember, we have three co-equal branches of government. Two here are working with one another. We've got the courts and we've got the executive branch, which is being embodied through the prosecutor's office. The prosecution is a body, an arm of the executive branch, and they are sort of battling with each other right now. The court is saying you're disqualified, but the prosecutor's office is saying you can't disqualify us. We're a co-equal branch of government. How dare you, sir? And they're saying you need to reconsider and let us sort of back on the case. If you try to exclude us, you're excluding a co-equal branch of government, and you don't necessarily have the authority to do that. So that's what the government is saying there. Now, they've also got some pretty good arguments going back the other way. Now, this judge already issued this order. It's already standing. And so they have to convince the court to reverse itself, essentially. And what are they asking, or what are their arguments to that effect? They're saying that none of these four prosecutors who were part of the judge's order prohibiting them from being involved in the case, none of them are actually necessary witnesses, is what their argument is. They're saying, yeah, they may have been in that room and had that conversation, but they're not needed to come into court to testify. The defense, or in this case, Derek Chauvin's lawyers, they can get all of the information that they want or they need out of Dr. Baker. They can actually just ask him the questions that they want, and he's going to be inclined to give them all the answers. They can ask him about undue influence or unethical conversations. They can really dive into the nuts and bolts of what happened at those meetings. And so none of those other attorneys who work as prosecutors, none of them are even necessary. Therefore, this rule doesn't really apply to them. they can get all the information they want out of Dr. Baker. They are also making the argument that those 4 attorneys, they're not even the attorneys on the case. So they're not even advocates. So how can they be subject to the advocate witness rule if they're not even going to be advocates in the case? Hennepin County Attorney Office, these high-level managers and these deputy chiefs and assistant chiefs and whatever scheme they have there of organizing their hierarchy, many of those people are not going to be in court doing the advocating. That's going to be reserved for the attorney general. The case has already been reassigned, and so they're just saying, well, what is the court even saying that these people are prohibited from? They're not even on the case anyways. They're just involved in the county attorney's office. And so that's another argument they're making. And finally, they're saying that the ABA, the American Bar Association, and a lot of the ethical rules that they're citing also say that it's totally proper to have these types of meetings. They encourage one-on-one meetings between prosecutors and witnesses. And here we had 4 experienced prosecutors. Therefore, there can be no misconduct. And so that's what their arguments are. We're going to see what the judge has to say about this. And we looked previously, we know that the next court date coming up is going to be on 9/18 in the George Floyd case. They're going to have additional arguments or an additional proceeding, or we may get a ruling on this motion, or the defense may respond. So a lot of interesting things happening here. I mean, this is something that does not happen often. You do not see a judge, especially on a very high profile case, disqualifying the county attorney and 3 of his top subordinates. You just don't see that. So it's going to be very interesting to learn more about what happened on that Friday omnibus hearing court proceeding, because we just don't know a lot about it yet, but we can glean a lot of information from the state's response. And certainly they do not want their most prestigious attorneys in their office to be disqualified from a case of this magnitude. So it will be very interesting to follow along. We hope you follow along with us, which is why you should absolutely hit that subscribe button. And if you like what we do on this channel, if you like these types of analyses, these deep dives that we do here, do us a favor and share it with your friend so that they can also be a part of the conversation. We host a show here every Wednesday called Watching the Watchers Live, where we hold police, prosecutors, judges, politicians, and anybody else in the criminal justice system accountable, because we believe that transparency, sunlight, is the best disinfectant and the best way forward for helping to create a more just justice system. So hit the subscribe button, tune in. We'll see you on the next one. Thanks for watching. All right, we are waiting for the stream to get cranking here. Looks like we are broadcasting on Periscope, so we're live on Twitter. We are now live on R&R Law Group. Looks like we're live on Facebook. The only thing we're waiting for is YouTube, and it looks like we're live there as well. Hello, everybody. Welcome back to another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney. My team and I, over the course of many years, we've helped thousands of people facing criminal charges go through the criminal justice system. And what we've decided to do now is actually sort of amplify what we're doing here. We're helping people through the process, but there are still some major issues throughout our criminal justice system that need to be addressed. And so what we have here is a show called Watching the Watchers, where that's exactly what we do. We're identifying misconduct. Hang on one second. We're identifying misconduct from police officers and prosecutors and politicians and basically anybody who's involved in the criminal justice system. We want to hold them accountable, because unfortunately what we see happen too often is a lot of these people are sort of masquerading as good guys. They're going through the criminal justice system and they're committing a lot of misconduct, a lot of malfeasance. And the best way to highlight this and the best way to root it out is by shining some sunlight on it, by notifying the general public about what is happening. Now, I'm getting some notifications that YouTube may not be working here, so let's take a quick moment and check. You're going to notice that things look a little bit different on the stream, and so as I'm sort of going through this introduction, we are going to be troubleshooting a couple things. You can see here that the background is certainly different, and I'm trying to identify why YouTube is not showing up. Is anybody on YouTube right now? It does look like we have some people on YouTube, but I'm not sure why it's not showing up on our main channel. Anyways, that's all right. We're going to keep going on with the show, but a couple things. So you can see that there's a new background here. We moved into a new office, and for the last week or so, I have been really trying to put together a new background and try to level up our YouTube production capabilities. And so what you see behind us is the new permanent studio. On the other side of this camera is a gigantic mess of cords and lights and cameras, and I'm still trying to figure it all out, but this is what we're working with today. So if there are any technical problems with this stream, I apologize in advance. Now, the other thing I want to share with you is something happened to me this past weekend that I don't usually like to talk about too much, but I had a birthday, and I'm not a big fan of birthdays. I kind of like to just be left alone a little bit on the birthdays and let them come and pass. Not a big celebration type of guy. And people in my life, they won't let me have that. So the office here actually threw a party on Monday to celebrate my birthday and another person's birthday and a 1-year anniversary. And so we had a little bit of a celebration, but I got a gift that I absolutely had to share with you on the show today because it's something I'm super proud of. So let me show you what I got. This came from a dear friend of mine here. She works here. Her name is Mrs. Harleen. She's awesome. And so they brought out gifts for me, and this is what I received. Let's take a look. Watching the Watchers. That's right. It's a t-shirt. So you can see here it's got our logo, the Watching the Watchers logo right there. And what good would a shirt be without the hashtag on the back, Bad Popo? The Bad Popo hashtag. We call bad police officers bad popo. We call them bad prosecutors, and so on and so forth. So awesome gift. Now, once I end the show and I put this on, I do not anticipate that this ever leaves my body. But that is enough about the introduction. Let's dive into the actual program here. And so I want to start off with going through more Kyle Rittenhouse. This has been a story that I think is really one of the most paramount sort of our time as it comes to self-defense. And when we're talking about gun rights and the freedom to carry firearms with you and to protect your life, protect your property, there's a lot of issues at stake here. And I want to spend a little bit more time on it. Now, I don't want this channel to become the Kyle Rittenhouse channel, but there is some important things, that are happening here that I really want to spend a little bit of time on. So since last week, there have been some developments. Now, on this channel, we've spent a lot of time covering a lot of different aspects of the Kyle Rittenhouse case. If you remember, we did a detailed analysis on the actual incident that night. We talked about the beginning, the first sequence of shots, the first shootings, the second sequence. We talked about the judge who was assigned to the case. We talked about the prosecutors who were assigned to the case. Today, we're going to talk about the defense attorneys who were assigned to the case, because if you've been following this, you know that both of the gentlemen who were involved in actually representing Kyle Rittenhouse are sort of in the middle of their own legal problems, and the same due diligence that we gave to the judge, the same due diligence we gave to the facts, the same that we gave to the prosecutors, we want to give to Kyle Rittenhouse's defense team, because he's going to be working with these guys for the foreseeable future, and we want to make sure he's got a good team in place. So we're going to get to that today. But before we do, let me give you an update on just what's going on with him. So last time we spoke, Kyle Rittenhouse was in Illinois. Now, he's still there. He has not been transferred yet back to Kenosha, Wisconsin. You remember this all took place in Kenosha, and he sort of at the end of the video sequence, he's running back towards the police. He has his hands up, and he's got a gun on his chest, and he's just sort of surrendering to the police. They drove right by him. Anyways, he left. He went back to Illinois. In Illinois, he had an extradition hearing, which means they were trying to talk about what it's going to take to essentially send him back to Wisconsin so that he can have his day in court there. So right now he's in Illinois, and he had an extradition hearing that was scheduled previously, but it got moved. There was a continuance in the case, and so it's now rescheduled for September 25th. He'll be back in court on that day for his extradition hearing. Now, that's in Illinois. In Wisconsin, what happened was the judge there actually set a bond. So in other words, the way that this worked, when Kyle Rittenhouse left Wisconsin and went back over to Illinois, the court said he's due in court. We have new criminal charges for him. He's not here. What are we going to do about that? So they issued what's called an arrest warrant for him, and they said, if you arrest him and bring him back into our custody, we are going to keep him in custody unless he posts a certain amount of money in order to get out of custody. Now remember, this is very important because Kyle Rittenhouse is 17 years old. These types of cases, these criminal charges, literally take years and years and years to go through the justice system. So if Kyle Rittenhouse is in bond, in custody for the next 2 years, that's going to be a problem for him. It's a problem for any criminal defendant. It's a problem for anybody who goes through the justice system. We've represented many people who've been in these situations, who are currently in these situations. And from our perspective, it's a difficult thing for a person to endure, right? Of course, you, as a common sense person who's never been to jail, you can understand how difficult it could be to go from somebody who, like Kyle's situation, is 17. He's, presumably in school. He's a lifeguard. He's trying to, grow up essentially. And for the next year or 2 years or however long it takes to get him out of custody, his life is on hold. And it's not just on hold, it is being dramatically impeded by the criminal justice system. So this is one of the most critical parts of a case. We need to get him out of custody so that he can get back to life, get back to school, get back to a job, show the rest of the world that this is not somebody who is out running around with an AR-15 just trying to kill people, right? He's trying to do something productive, got caught up in a bad situation, did what he thought he needed to do to protect his life and his well-being, and now he's being charged with a crime and he's going through the justice system as a result. So the problem with being in custody for 2 years is that this is a process that is just sort of, I don't want to say it's designed to just deteriorate a person's willpower, but it absolutely does that. The system is sort of meant to just grind people into a pulp so that they have very little choice to do much fighting anymore, right? They're sort of incentivized to take a plea deal, close their case, because if they continue to fight, then they're going to continue to be in custody and they're going to continue to have this stuff over their head for a very long time. So a person in Kyle's position he's got a long road ahead of him. In other words, people, this process causes people to take plea deals that they may otherwise would never have taken, because they want some finality in their case. They want to get out of custody. They'll take anything. They'll just say, all right, look, yeah, I'll plead guilty to that. How much more time? 5 years? Fine, I'll take it. Because they're just tired of the process. And you have to think about the stress. Kyle's facing some charges that would put him in prison for the rest of his life if he's convicted of all of them. So to have that constantly weighing on your head, it's just incredibly burdensome. So getting Kyle out of custody is going to be a big focus. And there's a lot of work left to be done on that. He's in Illinois. He's going to get transferred back. And what we have seen thus far is the judge in the Wisconsin case. So once he does come back over to Wisconsin, the judge put a bond on his case of $2 million. So you can see that right here. This is a screen grab that I took today from the court's website itself. And you can see a couple items here. So this happened about 2 weeks ago. But Kyle, there was a warrant issued for his arrest. We've already seen that. It was issued by the judge, Mary K. Wagner, who also set a bond of $2 million. Okay, $2 million is a significant bond, but is it really that different, or is it really that inappropriate for Kyle's case? Well, that's what we're going to dive into today. We're going to look at the rules for the Wisconsin statutes that will detail what is an appropriate bond and what is an inappropriate bond. So the judge in Kyle's case did say that it's a $2 million bond. That's a very high bond. I covered this last week, that there's another defendant, Crystal, who is also out of Kenosha, who is also being prosecuted by the same DA, who had I think it was a $1 million bond that was reduced down to $400,000. And we did sort of a case-by-case comparison on Crystal's case and Kyle's case, and we saw that they sort of didn't really match up. Why was she getting a $400,000 bond, but he was getting a $2 million bond? Hers originally started at $1 million, was dropped to $400,000, and Kyle's is still at $2 million. So we want to just go through the rules, right? What are the judges looking at? What are the prosecutors looking at? What are the defense attorneys looking at? And we can see if there are any arguments that may justify getting Kyle out of custody without posting that $2 million bond, right? Now, one other important thing to note, and this is a long sort of segue here, but it's important to note that this judge, Mary K. Wagner, so this judge who posted this bond here, it really hasn't seen anything yet, right? Doesn't know much about this case at all, other than what she saw from the charges that are going to be posted, or that were posted in the probable cause statement from the prosecutor's office. That's all the judge knows. And from what we've seen here, I looked through the more recent activity on the case, but I don't see a lot of activity. There was a proposed order that happened the day after the warrant was issued, and that's about it. So I really don't know if there has been any sort of movement from Kyle's defense team to file motions to modify their release conditions, or whether they've had any presentations to the Wisconsin court. We just don't know that yet, but we will soon enough. So my point is, Mary Kay Wagner, the judge who issued this bond, is sort of probably flying in the dark, or supposed to be flying in the dark. Now, this judge is going to know everything that you see on the news and in the media, but in terms of the concrete evidence that is in front of this judge, they just haven't seen it yet, or probably have not seen it yet, which is why there may be some wiggle room on this bond once Kyle does get transferred from Illinois back to Wisconsin. All right, so now let's talk about the actual, what are the rules in Wisconsin? And they have some pretty good rules that I think are actually favorable to Kyle Rittenhouse's case, but he's not in Wisconsin yet. When he does get there, I think that there are some pretty good arguments that this bond should be reduced down, or there should be no bond, or there should be some other sort of limitations on his ability to be out of custody. And we're going to talk about that. But let's take a look, first and foremost, at the eligibility for release. So Kyle Rittenhouse is in custody. He's going to be transferred back to Wisconsin. What is a judge going to look at when they're determining whether or not to release him from custody? So here we go. This is from section 969.01 of the Wisconsin statutes, and here's what it says. It says, a defendant arrested for the criminal offense is eligible for release under reasonable conditions designed to assure his or her appearance in court, to protect future members of the community from serious bodily harm, or to prevent intimidation of witnesses. So that's a long way of saying there's three things that the court wants to consider when they're going to be releasing somebody from custody. One, is he going to come back to court? Is Kyle Rittenhouse going to show up to court? They need him to show up to court. That's the primary purpose of these release conditions. It's to get him present and going through the process. Does anybody think that Kyle Rittenhouse is not going to go to court? Maybe some people do, but in my mind, that is kind of a no-brainer, right? He's going to go to court. He's a subject of national media attention. This guy is not going to slip under the radar. People are going to know where Kyle Rittenhouse is. The other issue that the court wants to discuss prior to releasing somebody is whether or not there's going to be any issues protecting members of society from Kyle Rittenhouse. So the second major facet is whether they can protect members of the community from serious bodily harm. And again, is this something that Kyle is going to go and shoot more people? This entire situation, in my mind and in our analysis, and it's not just mine, there are many other defense attorneys throughout the country who are saying this is clearly self-defense. So if he doesn't have a history of being proactive and going and finding people to shoot, then, and this is just purely a self-defense issue, that prong, I think, is pretty easily met. And then finally, the law itself says that we want to talk about identifying or protecting people, protecting against the intimidation of witnesses, right? So on this final last prong here, the intimidation of witnesses. Are we going to see that in this case? Is Kyle Rittenhouse going to intimidate any of these other people? I just don't see that, right? He's a 17-year-old kid. He's in a bad situation, and this is not something that I think he's got, a gang, or he's got the resources that are going to go and really undermine other witness statements in this case. And quite frankly, there really aren't that many other statements. From the government's own probable cause statement, we had the two witnesses who two people died. We had the reporter who essentially, McGinnis, who was actually talking in the probable cause statement and making claims that, in my mind, actually backed up Kyle Rittenhouse's claim. We have an unnamed individual, and then the other victims are just the government. It's just, well, he was there and he shouldn't have been there is what the government is claiming. He shouldn't have had a gun or whatever, the basis of that misdemeanor charges, which really isn't that important in my mind. So that is, those are the three things that they're considering, and I think Kyle Rittenhouse has a strong case for all of those. Now, what's important to note in this statute also is that the government doesn't have to just automatically impose bail or impose a bond. Because Kyle Rittenhouse was charged with some serious things, you sort of jump to that conclusion, right? You just start to say, well, because he's being charged with murder, we got to post a high bond, or really high bond. That may be what the judge was thinking, but really that's not what the law says or what the law requires. Here's what it says. It says that bail may be imposed at or after the initial appearance upon finding by the court that there is a reasonable basis to believe that bail is necessary to assure appearance in court. Okay, so it's necessary to assure appearance in court. In determining whether any conditions are appropriate, the judge shall first consider the likelihood that the defendant appears if released on his own recognizance. Okay, so what does that say? That's explaining, it's saying that the court doesn't automatically have to go and put a bond on Kyle or on anybody. It says that if there's a reasonable basis, so they have to look at the facts and say there's a reasonable basis that the bail is necessary to make sure that Kyle shows up in court. Did that analysis take place? We don't really know, right? The judge just looked at the case very early on in August 28th and set a bond at that time. We've learned a lot more about the case since then. And so this may be ripe for a reconsideration. We don't know if the judge actually did make that reasonable determination whether bail is necessary. But more importantly is that it's not even automatic. In other words, the court can go through, has to, it actually says shall, first consider the likelihood of the defendant appearing for trial if released on his own recognizance. You see that right there? That is the court saying if there's a possibility that we can just let him out without having him post bond and he'll come back, then we don't even need to post a bond, right? We should first consider whether he's going to show up. Otherwise, why do we need to even impose a bond in the first place? So I think just looking at some of those factors, and Kyle's got a pretty good case, and it's going to be something that is going to be very relevant. Now, let's say that the judge does determine that this person is eligible for bail. What are some of the factors that they need to consider? So the law goes on. So that was just the introductory part of the statute. The things that Kyle's attorneys are going to need to be looking at are included further down the statute in a different part of the law. And here's where the law, I think, is really on Kyle's side in a lot of different ways. We can look at the text and we can start to sort of see which ones are in favor and which ones are not. So what I've done here is I've actually copied and pasted the statute from the Wisconsin statutes and put it here in a slide, and I've broken it down into bullet points or numbers so that you can see specifically some of the things that the judges are going to be looking for when they're determining whether or not to release Kyle. All right, so let's go through them. Now, the stuff in green is stuff that I think is sort of favorable to Kyle. The stuff in the red is not so good for him, and the stuff in the yellow is sort of open to interpretation. So let's read through the statute. So let's say the judge says this is a case where Kyle can get bail. We're going to let him out of custody. The court says that if it is imposed, or the statute says if it is imposed, the bond amount shall only be in the amount found necessary to assure the appearance of the defendant. So once again, necessary to ensure, or here to assure the appearance of the defendant in court. Is a $2 million bond necessary to make sure that Kyle appears in court? If they made it a $500 bond so he could get out, would he still come to court? So it should only be the amount that's necessary to ensure future appearance. That's what this statute says. Something that's way too big or way too overbroad doesn't meet those elements of the statute. It becomes more punitive rather than it is helping to ensure that the criminal process is moving forward smoothly. Okay, think about that. If the amount of money is so high, it can be punitive. Now, Kyle has not actually been convicted of anything yet. He's been charged with crimes, but he's innocent until proven guilty. He deserves his day in court. But if a judge posts a bond that is $2 million and there's no way that he can hit that amount, then essentially he's being deprived of certain freedoms, whether you agree with it or not. He's being denied certain freedoms and he hasn't been convicted of a crime. So the judge needs to do a very careful consideration on all of these factors. We're taking somebody who is innocent and we're depriving them of their liberty. So what are the factors that are going into play, and what are Rittenhouse's attorneys doing to make the appropriate arguments to help ensure that his release is secured? So let's go back to the statutes. What they're going to be looking at here is they're saying that the conditions of release may be imposed for the purpose of protecting members of the community. We've already spoken about that. We are also talking about preventing seriously bodily harm. We're talking about preventing the intimidation of witnesses. And so the court goes on, and the statute goes on, and it says that these are the reasonable conditions of release are, right? The first one, which is sort of up in the air for Kyle, is whether the person has the ability to even give bail. So does Kyle have the funds to get out of custody? Can he post a $2 million bond? I have seen no evidence that he comes from a rich family, or that they have the means to even come close to that. I'm not an expert on the actual mechanics of bail and bond in Wisconsin, but I have heard from other attorneys who are familiar with it that if Kyle needs, if it's a $2 million bond, he's got to post the full amount of that $2 million. Does his family have that? I highly doubt it. Is the general public going to be willing or able to help him generate that amount of money? I think potentially. I mean, that is a massive sum of money. We have some of the lawyers for Kyle Rittenhouse, I think, doing some fundraising and engaging in some campaigns to help assist with that. But I've also seen some other headlines throughout the news showing that some of these actual fundraising, crowdsourcing programs and entities and business entities like GoFundMe and some of these other ones, I don't know about them specifically, but they're actually not taking money for this type of a case. And so they're not allowing their platforms to be used to help fundraise for Kyle Rittenhouse, which is, of course, sounds like a double standard to me. I think there's a lot of politics going on in that decision, not necessarily, fairness or equality or any of those things. All right, so let's go back to the statutes. The second factor that the judge needs to consider in determining whether Kyle should be released is the nature, number, and the gravity of the potential of the offenses and the potential penalty the defendant faces. Right? This one is obviously not good for Kyle. The reason is pretty obvious, right? The nature of the offense, they're murder charges. Intentional homicide. He showed up. He intended to kill these people. And there's no self-defense claim. That's going to be the government's position when they're discussing this factor. The self-defense can come into that equation, into that analysis, but still the severity, the gravity of the offense is very high. It's the highest thing that we have, right? And other people are dead. The penalty that Kyle faces are also very severe, very high, right? He can go to prison for life if he's convicted on all of these charges. And then the other bad red factor here is whether the alleged acts were violent in nature. That's sort of debatable. You could look up that statute and decide, what is violence versus self-defense. Violence to me has sort of the connotation that you are doing something that is inappropriate. You're being violent when it's not justified. Violence is unjustifiable. Whereas if you're defending yourself, somebody else was engaging in violence, not you. You were defending yourself. They were the ones who were being violent. You were just being a good person, protecting your life and your property. So I'm not real sure, how that factor goes in, but I think many people would just say, hey, he fired a gun and other people are dead. That is close enough to violence that factor may not weigh in his favor. But I think there's strong arguments that go the other way. Basically everything else, in my opinion, is good for Kyle's case. And again, these are all directly from the Wisconsin statutes. The next we have number 4, the defendant's prior record of criminal convictions and delinquency adjudications, if any. The only thing that we are talking about here, Kyle has some traffic tickets that also happened, I think, in Wisconsin. Very minor. One was going 20 to 24 over the posted speed limit, civil ticket, not a criminal charge. To my knowledge, I don't know of any other criminal history that he has whatsoever. And so that factor weighs in his favor, that the judge can look at that and say, this guy's never been in trouble before. And why, if he's never been in trouble before, then how can he be a danger to the community? This is one aberration. This is not a pattern of somebody who's willfully breaking the law day in and day out. Factor number 5, the character, health, and reputation of the defendant. And, this is an interesting one, right? Because Kyle is super young. Character, health, residence, and reputation of the defendant. He's very young. He basically has no reputation. We know very little about him other than the fact that he's 17. I understand he's a lifeguard. He was there trying to, remove some graffiti and protect some property. And he's got a lot of pro-police Facebook posts and things like that. But other than that, we don't know much about the guy, and nor should we. He's 17. His residence is in a different state, which is somewhat of a concern, but I think we can cure that issue if we sort of craft his release conditions in a different way. The character and the strength of the evidence is number 6. The character and strength of the evidence, which has been presented to the judge. we did a deep dive on this one, right? We went through the case line by line in the probable cause statement. We went through the video. We did an audio video frame by frame analysis on this channel, and it all looks like it favors Kyle pretty substantially. So I think the character and the strength of the evidence weigh majorly in his favor. The number 8, we've got whether the defendant, number 7, whether the defendant is on probation, extended supervised supervision, or parole. Kyle has not been in trouble at all, ever. So he's not on probation. He doesn't have any other pending cases, no other pending cases here. He hasn't been bound over for trial after a preliminary examination. He's got nothing going on. He hasn't had a past forfeited bail or violated a condition of release. He wasn't a fugitive from justice at the time of the release. And there's just no evidence that he's a threat to the community at all. So all of these different factors, protecting the community, preventing the intimidation of witnesses, assuring he can show back up in court, I think they all weigh in his favor. Now, they're also in factor number 11. These are not numbered. I just numbered them out for the ease of dissecting this statute. If you look at the statute itself, it's actually just a big, messy word salad paragraph. So broke it down for you here. The policy against unnecessary detention of the defendant's pending trial. So, the idea is that he has not had his day in court, and we want to get him out of custody so that we can, allow him to live his life. He's innocent until proven guilty. Those are some of the factors that I think the court by law, by statute, is supposed to consider. And there are some other things that they can do according to the statutes to really cure any of the other problems. All right. So let's think about it this way. If the court decides, all right, listen, we understand your arguments. We know he set a $2 million bond, but we're going to end up, make your arguments. We're going to release him, but we have to do these 3 things. We have to make sure he shows up to court. We have to make sure he's not a danger to the community. He's not a flight risk. And we have to make sure he doesn't intimidate witnesses. How can we do that? Is there anything that the law allows us to do so that Kyle can get out of custody over these next 2-3 years while the case is pending so that he can live his life and continue to develop as a young man? Well, fortunately, the Wisconsin statutes do provide some alternatives. They give us some options that we can use to craft a good release schedule. So here's what that statute looks like. So it's 969.03. This again comes from Wisconsin. Here's what it says. A defendant charged with a felony may be released by the judge without bail if a couple things can happen, right? They need to ensure that the person appears for trial, and they can impose these conditions to make sure that that happens. So a couple things that they can do. They can place the person in the custody of a designated person or organization. So they could give, basically custody of Kyle to somebody, to his mom, to his parents, to an organization for young men, to a school, a charter school. So, there has to be some organization in the United States who is willing to step in and say, look, we're gonna vouch for this kid. We're gonna make sure that this young man, make sure that he is in our care, and that we're not going to allow him to do anything that's going to impede the goals of the court. They could easily do that. They could also place restrictions on the travel, the association, or the place of abode of the defendant during this time. And so here what we're talking about, well, Kyle's place of address, where he lives, is in Illinois, in Antioch, and he could easily, move. I think it's not far from Kenosha. He could move over to Kenosha. He could put permanent residence there, or a place in Wisconsin, or a place right on the border, or they could craft some sort of option for him and say, look, we're going to let you out of custody, but you've got to do this, this, and this. You got to stay here and do this and report home and do all of those things, which would be significantly better than sitting in custody. They can also prohibit the defendant from possessing any dangerous weapons. So that is a no-brainer, right? Let him out of custody, release him on his own recognizance, and say, you can't touch a firearm. If you touch a firearm, if you're near a firearm, if you're in the same building as a firearm, if you go to a gun store, you're going back into custody. Okay? Don't get near it. That would be a good way to cure. They could release him and say, just don't touch a gun. If you do, you're going back in. I think that would be pretty reasonable as well. They could also require, of course, we've talked about this, the execution of an appearance bond, and they can do other things reasonably necessary to assure the appearance as required. and protect the members of the community and prevent the intimidation of witnesses and return to custody at the specified hours. So how do you do this? There are many ways you can do this. There's no reason he has to sit in custody for 2 years. You can do this with house arrest, right? You can just send him home and say you're not allowed to leave home. How do they monitor that? Well, they'll do it with ankle monitoring. They'll put ankle bracelets on. They also have devices that you can install in your home, and you can connect them to a landline. So I don't even have a landline at my house. I have a cell phone. That's the only thing that I use. But there's equipment that you can buy. You put it in your home. You connect it to a landline so they know you're there, and they call you every now and then. You got to check in, make sure you're there. They've got a video conferencing and all sorts of things that they can do to protect that balance. Right now, there are many people who are probably watching this saying, "Yeah, but Kyle's innocent. What the heck are we doing? Why are we going to not allow him to have a gun or allow him to go do certain things? The guy is innocent," which I can empathize with that. But the court has to balance these things, right? The court is going to be saying, well, technically there are 2 people dead, another one shot, and this guy, we don't know much about him, so he's a danger to the community. So they have to balance it. They have to protect the community, make sure he's showing up to court, and protect his freedoms, protect his liberty, make sure that this kid is getting the proper representation and the proper arguments are being made on his behalf, I think is where I'm going with that. And I think it's very important. So eventually this is going to become ripe. We're talking about it a little bit prematurely right now because Kyle is still in Illinois and he's going to be going back to Wisconsin soon, presumably after the extradition hearing, but this could take months. When he does get back over to Wisconsin, they're going to have that $2 million bond and it's going to need to be addressed. This is something that we do pretty regularly at our firm. If somebody comes to our office and they're in custody, we file what's called a motion to modify their release conditions all the time. I mean, it's a very common type of thing. The judge knows about the case just on some of the the basic factors that were available at the very outset of when everything started. But when we start working on a case, we can start to humanize somebody and start to say, okay, yeah, he was charged with intentional murder, but here's the story, right? He's 17 years old. He's never been in trouble before. A couple speeding tickets. He's a lifeguard. He's got a loving family. He's got, not to mention all of the legal defenses in his case. But let's just talk about the human side of this case. And so you make those claims, you go back to the court and you say, look, here's our plan. If you release this individual, here's why it's important. We need him to work on his own defense. We need to do interviews with him. He's going to need to, sit with us and analyze exhibits and do all of this stuff. It's a better environment for his defense to keep him out of custody. Whereas somebody who's in custody, the attorney's going down there all the time and they've got it's just a big ordeal. So it's a lot easier for his defense. It's a lot easier for him personally, right? He can go back to school. He can get a job. He can show the world that he's actually not a murderer. He's just a young man who's in a bad situation. And so this is super important. And in addition to that, it's just right. It's the right thing to do for his mental health, his mental well-being. To have him sit in custody for the next 2 years is going to be very detrimental to his his whole life is changed, obviously, as a result of this, but keeping him in custody without human contact, especially during these very sort of formative years of a young man's life, that is going to be a tall order for the next 2 years. So the question then becomes, are his attorneys going to be able to handle this? Are they going to be able to go through this process and do a good job? Now, before I jump into this segment, I know that this is going to be something that's probably a little bit unusual, but basically what I want to do is do the same thing that we have done with everybody else who's involved in the case. We went through the DAs, we went through the judge, we went through the different victims of the case. We know who everybody is. But we didn't spend a lot of time on Kyle Rittenhouse's defense lawyers. And specifically, we're talking about Lynn Wood. We're talking about John Pierce, who are the 2 attorneys who have been brought on by Kyle and his family or whomever is helping him make these decisions. And they're now representing him. And over the course of the last couple of weeks, we've seen some weird allegations sort of bubbling up about these 2 individuals that in my mind have been concerning. I've been watching this stuff unfold over the last couple weeks, and what I'm seeing feels like it's more about these lawyers than it is about protecting and defending Kyle Rittenhouse. And so what we're going to use the same lens that we used on the prosecutors and the DA, and we're going to look at these two gentlemen and really kind of decipher what's going on. The reason I wanted to take a closer look is because I started seeing some of this stuff bubbling up on Twitter, and I heard some of these kind of weird allegations that these guys were in charge of fundraising for Kyle Rittenhouse, and then they've got a lot of debt and a lot of these creditors making claims against them. So now people have concerns about the money. Is it really going to Rittenhouse's defense fund? Is it really going to be used for his defense, or is it going to be sort of embezzled and siphoned off to pay down some of these past debts? And I started thinking through that. I was, oh my goodness. That is troubling indeed. If they're going to be defense attorneys who are not putting their full force of their careers and their skill sets into defending Kyle Rittenhouse, then they're not the right attorneys for the job. If they're too worried about fighting off lawsuits that are attacking their personal, their businesses, and they've got these really massive outstanding debts, that is a disservice to Kyle Rittenhouse. And that's really the most important thing here, right? I mean, is there anything else more important than that? I mean, these guys past debts, these guys past businesses, these media appearances, or whatever that is. That's fine and appropriate to a certain extent in some cases, right? The attorneys are always going to get attacked. Defense attorneys get attacked in general, anyways. But what really is going on here is my point. So decided to take a closer look. The only thing that I knew about these two guys before we started jumping into this was what I saw on Twitter, and even then, some of the Twitter posts were curious, and we'll go through some of that here in a minute. But first, let's meet these two defense attorneys, and they are right here. We've got on the left, we have Lynn Wood, and on the right, we have John Pierce. And these are both attorneys who've been practicing for a long time. They've got big reputations. They've handled big cases, more nationally renowned cases than I have. And it's not my position to sort of judge the other attorneys' tactics or their techniques. I have my opinions on them, and of course I'm going to share them. But they're on the ground, right? They're on the floor. They know sort of what's going on. But there is a lot of stuff that is sort of muddying the waters to a certain extent. And I'll tell you this: if I can find it, if the internet can find this stuff, the prosecutor's office can find this stuff. The prosecutor's office will find it. They probably have teams of research assistants who are law school students just diving into this stuff and using it as a tactical advantage in their prosecution of Kyle Rittenhouse. So we're talking about it just to sort of shine some light on it, and then these people can explain it. They can explain it. And quite frankly, I don't want to hear an explanation that just says we're under attack by the left-wing media. Okay, that's not enough. The facts that we're going to get into here today warrant an actual response. Other than that, right? Anything that's just trying to parry off the criticism, well, that's just the left-wing media, that's just the liberal media, that's just people trying to engage in a smear campaign. That's ridiculous, right? We're looking at actual court documents here. We're going to be here in a minute. So enough of that introduction. Let's take a look at it. All right. So I want to start with Lynn Wood. Lynn Wood is an interesting he's an interesting attorney. We covered this last week. I wasn't real sure that we even saw much in terms of criminal law experience from Lynn Wood. My understanding is he's done sort of a lot more of the higher stakes media representation when it sort of requires a PR hand, then they bring him in. But in terms of criminal defense legal experience, I just haven't seen much of it. Doesn't mean that it doesn't exist. But here's the story. All right, so L. Lynn Wood had a law firm, had a corporation called L. Lynn Wood PC. He had a law practice, right? And this complaint that I'm going to show you was filed by 3 of his former team members. Now, the people who are filing the lawsuit against him are claiming that they were employees and that they should have been compensated and treated as employees. Lynn Wood is saying, no, they weren't actually employees. So here is the complaint itself. So you'll see here that this complaint, this is all public record. It's all available on basically any news site. If you try to look up this stuff, Lynn Wood, lawyer, lawsuit, whatever that is, you'll find it. It's available. And it was filed by these 3 people, Nicole Wade, Jonathan Grunberg, and Taylor Wilson, against Lynn Wood. These are his former employees, right? So he says that they're not, but they say that they are. and we're going to go into it. So here's essentially what happened. Let me give you the nuts and bolts. This is a massive complaint. Like, I think it's like 80 something pages long, very long complaint. I skimmed through a lot of it, but sort of read through the pertinent parts. And here is the gist of what ended up happening. So you have these 4 people who are working together. Linwood is the top, and then you've got these 3 other people who are hired on as partners. They've been working together for a number of years, and the allegations are from the 3 people who were, the employees or in the contested position. They are saying that Linwood is going in sort of a downward spiral and becoming abusive and erratic and holding these weird meetings at 2 in the morning, 4 in the morning. Weird stuff is going on. So they decided to part ways. So we have these 4 people in a law firm. 3 of them decide, all right, that's it. We're out. We can't take this stuff anymore, and we're going to leave. There's a big case that they were all working on together. So in civil litigation, these cases can last a very long time, years and years and years. And so they have a settlement on a case, and they come to an agreement that the attorneys who put work in on the case are going to be compensated accordingly. And, Linwood's going to get money, and they're all going to get sort of compensated accordingly. Well, as they decided to part ways, there was an agreement in place. So as they were leaving, Linwood and these 3 people entered into this agreement. There's a contract that says, we're leaving, but here's the compensation we want. We're going to take a couple of these cases that were with the firms with us, and we're going to pay you for that, and you're going to pay us for this. And so they settled the whole thing. There was basically like a divorce agreement, right? You get divorced. They were doing the same thing, and that agreement was entered into place. The problem is that the allegations are that Linwood is not honoring that agreement. So this agreement was entered into as a contract. It was signed. It was executed. It was fully official. And Linwood now does not want to pay on that. Doesn't want to pay, right? And so Linwood, of course, is on Twitter saying that he's being attacked and he's being smeared and all of that stuff. But let's take a look at the complaint itself. All right. So we have here one of the primary allegations from Linwood here is that he does not have to pay them anything because they were not employees. That's what he's saying. Now, I'm going to show you some pictures and some emails and some things, and you can tell me whether you think they were employees or not, but that's what the allegation is. So Linwood here is the defendant, and he is saying that the stated position is that the individuals were not in Lynn's firm at any time relevant, because they shared office space and they worked on cases with Lynn Law Wood. They were going to split fees and all of that stuff. He goes on to say that, so that's his claim. Now, let me back up here a little bit. So there's another kind of interesting factor here where Linwood is saying that all of these attorneys had their own LLCs. He was paying them as 1099 employees. He says, this is not unusual at all. In my second law firm, I was a 1099 and I got paid as that, but I was an employee of the firm. It was just for tax purposes. So that's just something that firms do. It's not unusual. It's not uncommon. It's sort of way of doing business for certain firms. Just the attorneys are responsible for paying the taxes themselves, which is not a big deal. So Linwood is saying they're not attorneys and they're leaving because, for whatever reason, we're going to enter this agreement, but then he refuses to actually honor that agreement because he says they're not employees. Well, in the complaint, the 3 people who are suing him respond back, and they're saying, no, not so fast. There's a lot of evidence that we were, in fact, employees there, and here's what it looks like. They're saying that there was a website where they were identified as partners on it. Wade, Grunberg, and Wilson were all identified as partners on Lynn's websites. His office made public announcements that they were joining the team. They were on the header, on the case caption for every single case that was filed. There were many other things. They got business cards. They got email addresses at linwoodlaw.com. There's emails, there's texts, there's all sorts of stuff that show that they really sort of were employees, that they were partners, that they were part of this firm, and so they're entitled to the same compensation that an employee or a partner would get, right? If they're not employees, Linwood is saying he's got an excuse not to pay them, but it looks to me like they're actually employees, right? And so here is another screenshot from the complaint itself. You can see here, this is an actual announcement that the plaintiffs here, the people suing Lynn, are filing, and it's saying they're pleased to announce that Nicole Jennings Wade has joined the firm as a partner. So she is now a partner. Okay, that is not sort of of a different type of an employment agreement. Now, I'm not an employment attorney. I don't practice in this space specifically, but I do run a business and I do have a law firm with a lot of employees here. And so I know a little bit about this just in terms, just from my own experience in practicing and building a business. If somebody joins as a partner, their interests are directly connected to the firm. I mean, they're integral to the firm. They're absolutely integrated into that. If somebody is not in that position, and let's say you just want to use them sort of, for certain cases here and there, you don't call them a partner, you call them of counsel. It's just a different designation. It's saying they have their own firm. We work together occasionally. But what we're looking at here is, it looks to me like this is an announcement saying this person joined the firm, right? We have an email address and Wade at Linwood Law. Everything is tying this back to her position there at the firm. And there's more evidence to support that. This is the case caption. So this goes at the top of every single document that's filed with the courts. We've got Linwood, which is right here at the top. And then we've got all three of the other people who are listed on the case caption. This is filed on cases this is going into courts. So courts are looking at this and they're saying, yeah, that firm has 4 lawyers there. We do that at our firm too, right? All of our attorneys who are our employees are on our case captions, and those get filed in every court. And in addition to that, we've also got a situation where Linwood is taking pictures with these 3 people and he's putting them on the website, right? That's all 3 of the plaintiffs there who were working with him, and they took a picture together and they promoted that on their website. So to me, that looks like a firm. That looks like employees. That looks like a longer term ongoing business relationship. And if that is the case, then it does seem to me that Linwood owes those people some money. If you read through the complaint, it's a very long complaint, highly detailed, but it sort of draws the connection, and it explains if they're employees, they're entitled to the compensation. They're also entitled to the compensation just due to the fact that Lynn signed an agreement with them at their departure. There was a departure agreement, and he should honor that. So that's concerning. That's concerning to somebody like me, right? If I was the type of person who hired a bunch of people, had them do a bunch of work, and then essentially parted ways with them and didn't pay them for that work, that is not a good thing. That is not what a good, honorable person with integrity does. So the allegations here are pretty serious. The complaint goes on, and it says here that the complaint is going to move forward, and it's going to start to sort of delineate some of the misconduct or the malfeasance that they're claiming Linwood committed against them in this complaint. And again, this complaint is public record. These are not my words. They are the complaint's words. So let's look at the complaint itself. So throughout late 2019 and January and February 2020, abusive, incoherent phone calls, voicemails, texts, and emails by defendant Wood to plaintiffs were made in the middle of the night. They were the norm. All of these erratic communications have a few things in common. Most of these emails profess that God or the Almighty was commanding his actions. Many were stating his refusal to pay the plaintiffs one thin dime, and virtually all were abusive. Now, I want to point out that in this complaint itself, these 3 people who are suing Lynn, they worked together with him for some time, and they make a point in this complaint to say that they are trying not to air out his dirty laundry. In other words, there's a paragraph in here. It says, listen, there's a lot here. We're going to tell you some of it because we have to, but our intention is not to be overly sort of exposing of the private conversations that Linwood had with his employees, right? Some of that stuff I understand. Some of that stuff is, you want to have certain confidences in people. I have no question in my mind that there are things that I have said or done in office meetings that probably were, over the top or offended somebody, or, it's something I shouldn't have said, or, things happen, right? We're all human. We all make mistakes. I get that. But what we're talking about here is something significantly more than that. It's more than just, being angry or being snappy when somebody asks you for something. I already answered that, or one of those types of things. This is really strange behavior and really kind of troubling to a certain extent. So the complaint goes on and on and on. But my point was, this is not something that they're trying to rub his nose in it. They're just saying, look, we gotta make our claim. We've got a ton of evidence, and so we're just going to start laying it out here. Complaints like 75, 80 pages long, and there's a lot. Okay, I'm not going to go through all of it because it's pretty bad, but I did highlight some things that I think are pertinent to what we're talking about here. And again, this is pertinent because this is Kyle Rittenhouse's defense lawyer. This is somebody whose job should be to his clients, right? And if he's being distracted by all of this other stuff, he's not going to be able to do as good of a job for his clients. I understand that people can chew bubble gum and walk at the same time, but this is something that is a big deal. And it's currently, in my mind, it's distracting from Rittenhouse's case. It's distracting from his defense, which is a big problem. Okay, he's a young man. Who knows how this all happened? But anyways, let's go into the complaint itself because it's interesting. All right. So the defendants say during a 3.5-hour phone call, there was Woods referred to himself as Almighty, offered to fight the individual plaintiffs to the death. He demanded the plaintiffs' undying loyalty. He threatened to hurt the plaintiffs. He offered the plaintiffs stay in the firm, and he called plaintiff Grunberg a Chilean Jew and demanded that he admit he does not look like the other lawyers in the firm. Unfortunately, the list goes on, as reflected by the ongoing pertinent portion of the transcript of a call, except as indicated by brackets and double quotation marks. The words are Defendant Woods. All right, so that was an interesting segue into this big wall of text. Now, I want to point out this is just one example of many. I mean, this is a very long complaint. There's pages and pages of these types of text and phone calls and emails. So these people who are suing him, the plaintiffs, they have everything. You know, they've got emails, they've got voicemails, they've got phone calls, they've got text messages, they've got it all. And they're just systematically laying this out one after another, and it does not look good. All right, so here is what they're detailing this. They're saying that 2 hours later, so they're going through a series of events, and they're saying, on this day, he did this. On this day, he did that. On that day, he did this. And so we're picking up here from one of those stories. They're saying 2 hours later at 3:45, Lynn Wood emailed them and 9 others, and he continued his incoherent allegations. He said with his belief that God was somehow commanding him or directing him to accuse the plaintiffs and repeating his threat never to pay the plaintiffs for anything for their services. He began the email by stating, God has given me permission to be profane in this email, which is my last email of the night, and additionally stating in material part as follows. So this is Lynn's actual email to these people. He says, you damn dumb MFers, you have now subjected yourselves and your families to the fact that you are all guilty of federal crimes, and you are going to be ruined financially, if necessary, in civil and criminal lawsuit. You committed computer fraud today and possibly bank fraud. Your lies and fraud upon law firms and your employers are going to come back quickly to haunt you for the rest of your lives. You effed with the wrong guy. You effed with Lynn Wood. Bad effing choice. Here are the findings of your final judgment day on earth for today, the day after my Valentine's Day massacre. This goes on. He says, this is another voicemail. He says, let me tell you something, you little snotty ass son of a bee. Don't write me back and tell me you're taking care of your son. Your son's looking into the eyes of a damn lowlife, cheating, lying, probably a criminal defendant. How could you do this to your family? FBI is not going to play around. You've all engaged in computer fraud. I don't give a damn whether you did it or if Nicole did it. I know who did it, and you got redacted involved. You've ruined everybody's life. You're not going to get one thin dime from me. The reason why that is in bold is because he's already entered into an agreement to pay them. He's already agreed to pay them. And now he's saying that he doesn't have to pay them, which is certainly concerning. You're not going to get one thin dime from me. Sue me. I don't think they'll allow you to file lawsuits like that when you're behind bars. Somebody better call me, put their baby down, and give me a damn truth. If there's going to be any mercy shown by anybody for you, including the FBI, blah, 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 blah. Somebody's going to jail. Don't go with him. Quit playing your games, you snotty ass little bastard. You came in here and rammed your damn mouth in my office and yelled at me. You're lucky I'm not with you right now, Taylor, because I do to you what I do to X. I'd beat your ass with a switch till you couldn't sit down for 20 effing years, is what he says. And, you know, it just goes on and on and on. This complaint is very long. There's a lot of it in there. There's one line about, threatening to have sex with somebody else's wife. And it's a lot of really, really bizarre behavior, really bizarre language. And we're seeing some of that actually from his Twitter account. I mean, quite frankly, this is something that is, available, I think, kind of for everybody to see. And so let's go over to his actual account. Let's take a look at it. Now, this is somebody, you know, he's tweeting almost all day long. I mean, he's very active on Twitter, and you can see here. So let's go to Linwood. Light always overcomes darkness. Truth always overcomes lies. And he's got, I looked at it earlier today, Jack and my friends at Twitter. So again, he's making it about himself. Fight back by going to our homepages and retweeting messages you believe would be beneficial to others. Here's what he says here. This was an interesting thread. So he posted this today. He says, this is from Linwood. Now, also, keep this in mind. So the complaint that I just shared with you, that was filed by one side. That was filed by the 3 people who were suing Linwood. They have full rights and full opportunity to file a response back. So they can respond to that. And when they do, when Lynn and his team respond to that, I will, of course, talk about what is in the response. I will... They should address everything point by point. We can take a look at some of their claims and see what his response is back to them. That being said, I'm not optimistic that he's going to have a good explanation for his behavior. All of this stuff is documented in voicemails, text messages, and phone calls. I don't know why he's speaking this way to them. It is, you know, not particularly good or professional way to do things or to treat people. I've worked for guys like this, and it's not good. And they don't particularly do very well because you can't treat everybody, you know, like a bully and expect to get ahead in this world. It's just not a good way to do things. Not a good way to live your life. But that's sort of what we're seeing in that complaint. That's my take on it. So when we go back to his actual Twitter account, we're going to see that he says, too many lawyers now make big decisions driven in large part by big and medium-sized law firms. They need to generate revenue. My profession is at its best when we as lawyers take on the controversial client or issue and do so without fear of negative publicity or threats of harm. Lawyers must always place the client's interest first and foremost in order to uphold our oaths as officers of the court and to adhere to the fundamental principles and ethics of our profession. Too many lawyers have forgotten the oath taken upon the admission to the bar. Money explains why public at large and so many clients have lost faith in our profession. Many young lawyers face crucial issue of whether they want to work for money or for the client. Stated differently, do they want to be a businessman or professional? The love of money has eroded my profession's principles. The love of money is truly the root of all evil. Businessmen make money. Professionals make sacrifices. It is difficult to find Atticus Finch in my professions today, which is very curious, right? We just looked at the complaint. He's just threatening that he's not going to pay them. He's claiming that they're not employees when, to me, it looks like they're pretty clearly employees. They got business cards. They're on your website as partners. They had email addresses there. They were on your case captions. I mean, you're essentially claiming that these young lawyers are trying to take advantage of you or they're too hungry for money, but the complaint is saying that you were the one who was abusive and you didn't pay them. So we understand what the front-facing Twitter account looks like, but the complaint doesn't quite back that up. Now, again, if he can respond to this and he can say what he needs to say in order to explain away their claims and their allegations, great. We're going to give him full opportunity and the full time to address that. I mean, if he wants to come on this show, if he wants to come on any show and address him, I'd love to hear what his explanation is for it. But to sort of, you know, post comments saying that other people are worried about money when it seems like he's the one worried about money is sort of the pot calling the kettle black, as they say. So that's Lynn Wood, and I happen to agree with him, right? Lawyers must always place the client's interests first and foremost in order to uphold their oaths as officers of the court. I completely agree with that, but we're just not seeing much of that in as it relates to Lynn Wood, not here anyways. So let's take a look at the other gentleman who was involved in this case, and of course we're talking about Pierce Bainbridge. We're talking about John Pierce. John Pierce is the other gentleman that we had spoken about, and you know he's got some issues too. We have to say it. We just have to call it out. Now, John Pierce is is nobody I know personally. I don't know much about the guy other than what we're learning about him. I have seen him appear on Tucker. I've seen his video. I think we played some of that the last time he was on the phone with Kyle Rittenhouse on this channel. But a lot more is coming out about this guy as well that is troubling. The primary focus here is Kyle Rittenhouse deserves an adequate defense. He deserves proper representation. And we just saw with Linwood that there's some allegations of some instability there and some pretty good evidence from what I can see to back that up. We're going to see what his response looks like and whether he's going to address any of those things on the merit. Same type of situation with John Pierce. John Pierce is a civil lawyer, from what I could tell, not a criminal lawyer, but he's helping Kyle Rittenhouse on his case. Now, I have no doubt that John Pierce is intelligent and could handle a criminal case if he needed to, but I don't see that he's got any experience from it. I know he's not from Wisconsin. Neither of these guys are. So my guess would be that they know very little about Wisconsin criminal procedure. I sure don't. They probably know very little about the judges and about the juries there and how they sentence and what the plea offers look like. And they probably don't have personal relationships with any of the prosecutors there. So, there's a lot of concerns just at the outset with these two guys representing Kyle Rittenhouse, just because the subject matter doesn't line up very well. These guys are civil attorneys. Kyle Rittenhouse has a criminal case. So why are they working on it? Well, I don't know. That's something that Kyle and his family probably made a decision on that regard. But as more and more comes out, and we're starting to see that, where there's smoke, there may be some fire. We have to ask the question, right? Is it time to reassess his defense team, and how is this going to work out for him if he does, and how is it going to work out for him if he doesn't? All right, so I want to share with you this link that I found over on Medium. Medium.com is a pretty great website. There's a gentleman over there by the name of Don Lewis who wrote 2 different articles that go into great detail about some of the problems that John Pierce is having in his life currently. And again, my point in going through this is not to rub his nose in it and to smear him or the specifics of his life or his case. It's just to highlight a fact, right? If we know this is going on, the public at large knows this is going on, the defense knows it, this guy Don Lewis knows it's going on, the prosecutor's offices are going to know this is going on. And this is going to be troubling for Kyle Rittenhouse. If these guys are focused on other things, they're not going to be focused on his case. That's my only concern here. So it's important to know that this is what's going on. So here, Don Lewis says that there's been all of this information going around, these allegations that John Pierce was leading some of the fundraising for Kyle Rittenhouse, leading it for his defense, his legal defense fund. And because he's so badly in debt, there were allegations that he was going to sort of take some of this money and apply it to his past debts. Now he comes out and he says, total fake news. Pierce Bainbridge PC has 0 debt. So keep that noted there, right? Pierce Bainbridge PC, 0 debt. I have stepped off the Fight Back board to avoid any potential conflict. Of course, the firm will have to be paid for some of his work and expenses so we can keep the lights on. Fight back, free Kyle. All right. So here is where Don Lewis goes through this in great detail. He says that the reported $70 million debt. All right. So financial picture of Pierce, Bainbridge, Beck, Price, and Hecht LLP is not pretty. The firm's reported debt is $70 million. All right. So you're going to see this a lot. Pierce, Bainbridge, and we're going to see a number of different sort of entities that are being created. So it looks like he's just sort of creating new entities. He's having one legal entity that accumulates a bunch of debt. He folds that entity up and then moves into a different entity and takes on new debt. So it's sort of like a Ponzi scheme. It was to a certain extent. It's kind of what it feels like. I'm not saying that's what it is, but it kind of feels like that to me. So here is what Don Lewis is saying. He's saying, okay, so something was going on November 7th, 2019. There was a Rudy Giuliani hired Pierce Bainbridge to represent him, and he actually did some deep dives on this. So he pulled an income and expense statement. He went through this. Now, again, this is all right on the internet. You can go to his article on medium.com and pull all of this stuff, but he summarizes it here. He says Pierce owed over $1 million in taxes. He owed his former spouse's mother $27,000. He owed Citibank $90,000. No investment incomes. His cash deposit accounts were only $10,000. Fair market value of all of his personal property was $0 or negative, actually. He has $49,000 of expenses every month. So essentially, he's got nothing, right? He files his income and expense declaration, and he has very, very little assets. But he's also doing this interesting thing where he is sort of changing the names of the law firms sort of from one entity to another. And there's this timeline that Don Lewis puts together here where he says, okay, here's kind of how this has been going on. He's got all of these actual lawsuits from these different cash advance companies who are suing Pierce Bainbridge and John Pierce and personally, and all of these different enterprises: Pierce, Bainbridge, Beck, Price, and Hecht, Pierce Burns LLP, John M. Pierce Enterprises LLC, JMP Enterprises, John M. Pierce, right? All of these different LLCs, because they owe a bunch of money. So Slade Advance was one of these organizations where $500,000 in upfront cash was going to be given to John Pierce and these entities in exchange for future receivables. So this is just a cash advance. So they're saying, hey, John, we're going to give you $500,000. We know that you're going to make $750,000 back, and so we want all of that money. We're going to give you $500,000 now. You pay us back $750,000. No problem. Those are just example numbers. I don't know what the actual numbers were in this case. Well, when John John Pierce and his enterprises didn't pay that money back, this lawsuit was filed. So they filed Slade Advance, sue him for that. Same story with this other lawsuit. We've got the Supreme Court. We've got the West Coast Business Capital. They provided $260,000 upfront cash, and they wanted $387,400 back in future receivables. So the same deal, and it's the same people: Pierce, Bainbridge, Beck, Price, and Hecht, LLA, Pierce, same people. John Pierce Enterprises, John M. Pierce personally. So between the two of these, you got $260,000 up front. He owes $380,000, almost $400,000 on that. Then we got $500,000 here, probably in exchange for future receivables with a much higher number. So he's probably looking at $750,000 that he owes just between those two lawsuits. He's got another one, right? He's got another one with Creative Capital Funding, who's essentially doing the same thing. Hundreds of thousands of dollars in upfront cash provided in exchange for future receivables. So he's just going around and he's getting a lot of cash advances, and then he's getting sued by the people who loaned him the money. We got 3 lawsuits, and we got full complaints here that Don Lewis has gathered, which is troubling behavior. We've got more of these different screenshots. We've got here another Karish Capital LLC, whereby $2.5 million upfront cash was provided in exchange for future receivables with daily repayments of $37,500 until $3.7 million was paid back. So he borrows $2.5, repays back $3.75, and in just recently, in July 22nd, 2020, the New York Supreme Court entered a money judgment for $3.99 million against John Bainbridge, or John M. Pierce Enterprises. So one of John Pierce's entities now owes $3.9 million, and you can see that here right in the breakdown from the New York case filing, right, towards Karish Capital. So between the 3.9 and another, $750,000, we're looking at almost $5 million that this guy is in the hole on. And now he is representing, Kyle Rittenhouse, and this just goes on and on and on. So what Don Lewis is claiming happened here is that he would just form new articles of incorporation. So in May 2020, he's got all of that past debt on those old companies. And so now what he's doing is he's just forming a new company. He's saying, oh no, we have zero debt. Obviously we have zero debt. We just formed the company. We haven't incurred any debt. So this is the articles of incorporation that were filed for Pierce Bainbridge, which is the firm that we're hearing about for Kyle Rittenhouse. And they've got on May 20th, this was filed. It's a brand new articles of incorporation. I mean, basically nothing in there, right? Just the absolute bare minimum that you need in order to form the articles. And he's got, these finance statements. He's got other lawsuits from, individuals suing John Pierce, another complaint here. Another complaint here. It just goes on and on and on, and it is not a good situation, right? And so we ask the question: is John Pierce in this for Kyle Rittenhouse, or is John Pierce in this for John Pierce, or is he in it for something else? Is there another reason why he is, really so gung-ho about representing Kyle Rittenhouse? Is it because that this case is going to be sort of a launch pad to something else that's going to help him cover these past debts that he is accumulating so quickly and moving companies around? So it's concerning, right? If, just like Lynn Wood said, if this stuff is distracting from the representation that Kyle Rittenhouse should be getting, that is a problem. He needs to have, competent legal representation with people who are highly focused on getting Kyle Rittenhouse the justice that he deserves and getting him out of custody as soon as possible. So that's what I wanted to cover today. Let's take a look at the chat. So let's take a look at the see what some comments we've got popping up here. All right. So Never Trust a Lawyer says, why is he not in jail for fraud? It's because he is a lawyer. Well, it's a good question. Yeah, it's a good question. He may be, he may have some concerns about being investigated for some fraud or for some financial maneuvering, who knows? But I think that's what sort of Don Lewis's position was, or what his statement was. Is John Pierce in this for something else? Is there something else he's trying to do here? I hate to say it, but this reminds me very closely of the Michael Avenatti stuff, where Michael Avenatti was representing the woman who was claiming she had sex with Trump, or maybe that's confirmed now. I forget what it was. I forget her. Stormy Daniels. This may have been the situation where Michael Avenatti was so badly in debt, and he was so hurting for money and exposure and fame, and he wanted to parlay his representation of Stormy Daniels into something else. Parlay that into a book deal, or parlay that into a media show. There were even people talking about him running for president. Remember that? And now he's I think he's in custody now for trying to extort Nike or one of those things. I forget what it was specifically, so don't quote me on that. But this is a concern, right? You've got attorneys who are very clever and who can make multiple LLCs and really maneuver things around. Now they are, trying to rob Peter to pay Paul, or however that phrase goes. That's what it feels like to me, and it's certainly concerning. A Fowler says, looks like a Ponzi scheme. Excellent work. Thanks, brother. Well, he beat the Rittenhouse case to even consider the civil suit. He has to beat the Rittenhouse case to even consider the civil suit. Any confirmation that Jacob Blake is guilty of any of the crimes he's accused of doing yet? So my understanding is Jacob Blake had his arraignment from a hospital bed, and so he's appearing on the new charges for the sexual assault case. I haven't looked into the facts on that. I do want to do an update on Jacob Blake, because I think there is some more interesting stuff that has come out specifically about the original allegation. So I haven't looked into that, so I don't want to dive into the details on that just yet. Bill Ekman says, seems like these two clowns are trying to gain some buzz to use this case to try to secure a big fat bag with future books or some BS. That's what it feels like to me. It really does. It feels like these two guys are more interested in posting on Twitter almost all day than they are representing Kyle, unfortunately. You can look at either one of their Twitter accounts and you can see a lot of that. All right. So any other comments? Let's see. The Second Amendment allows people that would otherwise be unable to protect themselves to protect themselves. The right to bear arms is synonymous with self-defense, and that comes from Exit 5398. I think that is a good point. Great. Now Kyle is surrounded by a couple of drama queens. That comes from Gordon G. And it does seem like that. These two guys, it's really weird. They're always talking about themselves, and they're not so much focused on Kyle. Could it be a smear campaign against Lynn Wood, since he took on the media houses and now Kyle? Yeah, I'm always open for that. I'm always open to that suggestion or that idea. So as I said, Lynn Wood is going to be able to file a response to this, And it would be my suggestion, my recommendation, that he addresses every single one of those complaints on the merits. And he says, look, yeah, I have a temper. It's okay to have a temper. You can't be abusive. You can get mad about things, but some of the language I think in there is really just inexcusable. I don't know how he's going to be able to respond to that, but I'm sure that he will. Let's see, any other comments? All right. I've got a lot of comments. Johnny Boy, will the people working with Linwood is the people that sue CNN, not Linwood? I'm not interested in an employee versus an employer spat. Neither am I. I'm not interested in that, truthfully. Brett Hogan says that this is boring. I agree with that. It is boring. It's not about that underlying interaction, right? I really don't care specifically what happened with Linwood and these three people who are suing him. What I do care about is Linwood is the attorney for Kyle Rittenhouse. And in my mind, he's being sued for a lot of money and he's got a lot of other things going on. And all he's doing on Twitter is talking about other things that are not pertinent to Kyle Rittenhouse. So it is boring. It's not relevant to the Kyle Rittenhouse case. And I do not think that it's productive. So if there's a takeaway on this stuff, it's maybe we should look a little bit more closely at these two people who are representing somebody in a case that I think is very important. So it's a seminal case for self-defense and firearms and the Second Amendment. It's going to be a big deal. And I want to make sure that he's got competent representation. Not two people who are being sued every which way from Sunday, who are just trying to figure out how to pay their electricity bills because they have no money. We want people who are with solid, reputable law firms, people who know how to handle the media, people who know how to represent a case or handle a criminal case in the state of Wisconsin, in the state of Illinois. Neither of these guys are from either of those states. So we just want competent representation. That's all I'm asking for. And it may be time for a change to happen. Let's see, any updates on the Prude case and the case with the guy got the bat who was shot in Walmart? Daniel Prude's case. No, I have not. I haven't seen anything change on that. I think that one's kind of, well, that's not true, right? So I'll have to look into that. I'll do an update on the Prude case. Is there any way you can help Kyle? That comes from Kenneth Reeder. I'm trying to help Kyle just by simply doing this show. I'm trying to sort of add some stuff to the conversation and help people think about things in a different way. That's what I'm trying to do to help. I don't know how qualified I am, quite frankly. I'd never practiced in Wisconsin law. I would be happy to help in any way that I could, but I just don't. I don't know that it's being asked right now, but I'm happy to. I mean, I know the case very well. We've been covering it for a long time. You should do a video about the death of Stephen Dolkamore. Basically died the same way as George Floyd in April. I'm going to look into that. I appreciate that. This case isn't about the Second Amendment. This comes from Zulu. He says it's about the specific event. The Second Amendment won't be affected by the outcome. I hope that's true. We are going to see, and so we had a lot of comments today. I appreciate that. We're going to wrap up the show now. Remember, we're going to be here again next week live at 4 o'clock p.m. watching the Watchers live from our new studio. And as a reminder, if you haven't already, and you need some help with a criminal case, or you know anybody that needs help with a criminal case, tell them to grab a copy of my book. It's called Beginning to Winning: How to Fight Your Case and Succeed in the Criminal Justice System. It's got a ton of information, all these different strategies and different things that you can do if you've been charged with a crime. It's available on Amazon, so you can pass that around. Otherwise, thanks so much for tuning in to this show. I know it wasn't the most interesting show because of sort of the details on the bond and a lot of law and a lot of legal stuff. A little bit of a slow news week, which is a good thing. Finally, every single week, it feels like everything's been happening so quickly that every day I wake up, there's a new story. So I'm glad that there aren't more people being killed by the police that we have to talk about today. That's good news. But it does give us some opportunities to really do a deep dive on Rittenhouse. I want to make sure he gets out of custody, and I want to make sure he's got good, competent lawyers who care about him and his case more than they care about themselves and their own cases. So thank you so much for tuning in. We will be here again next week, 4 p.m. Do me a favor, hit the subscribe button if you haven't already done so. Any other feedback you want to leave here is great. If you like the stream, if you don't, just let me know. We're trying to always kind of up level and get better at doing this type of broadcast. So I appreciate it. Thanks so much for sharing the show. We'll see. It happened, of course, in Kenosha, Wisconsin, and this is what it looks like. So let me get rid of that. But this is the map of the intersection. You can see it took place right here at 63rd Street and Sheridan Road. And if we zoom in, you're going to see this is the parking lot that we saw in that original video. So the original video, if we back up here, now this is going to be an audio warning because the audio is going to be quite loud, but this is the parking lot. You can see here the auto service portion of this building is located here. And when we go back over to the map, we're going to then see that it really is this. We're going to throw our little man here and hop down over onto Street View. And you're going to see that this is the same area. So this is where Kyle was. This is where he was sort of being chased down from this area. So we saw him turn the corner right around here and then loop back around, and the shots took place in this area. So when we go into the video, we're going to see somebody was sort of there were cars parked in this parking lot area right here, and there was somebody sort of filming from this angle. When we back out, we're also going to see that there was somebody on the other side of the street. So somebody, I think, over in this area who is going to be recording just from a different angle. So you got somebody looking from the right side, which is going to be the east side, and you've got somebody who's sort of on the north side of the parking lot who's looking southbound into that. And that matches, like I said, just what we saw. So if we're on Street View, we're going to see that all of this took place right here at that intersection. There's a lot of activity going on there. So that was the first grouping. So then the question became, well, all right, well, how much time elapsed between that grouping? The reason why this is important is because if the first original threat ended and he moved on to a different sort of area, this was a different situation when he fired that second grouping of shots, you could legally say that there were sort of separate incidents. But looking at it, I don't think that's the case. Here's why. When we go back to the map, the second video that we're going to see is really, really close by. So he takes, if you remember from the first video that we talked about, he's doing a loop sort of in this area. And we're going to go through the video again here shortly. But he's looping around in this area. He comes back over to this spot when he sees that the man was shot and he's sort of lying on the ground. He's got a bullet, I think, in his head, and he's not in a good situation. He picks up his phone to call for help. And then he starts to see sort of the crowd kind of descending upon him, and he takes off going northbound. He's heading northbound in this direction, and he runs right up this street. He keeps going for a little bit. Kyle's running, and right about here, just north of this 32 symbol right in the roadway, is where he sort of trips, and he fires the additional shots that actually connect with two people, killing them. I think it actually hits a third person at that. One person is shot and really hurts his elbow. I mean, he almost loses his elbow, his arm on that. And then somebody else is shot and they're killed right there on the scene. And so when we put our little man here and we hop down to Street View, we're going to see that this is all going to look very familiar here in a minute. So you're going to see this is the road that he is running down. So let's go back to the video footage. Let's go back to the second part of the clips. And we're going to see right here, this is the Street View portion of it. So we're looking here and you can see this little lit, looks like a gas station or something down here as Kyle is running down the street. There he is on the ground. We're going to see this building right here, and we're going to see this fence. And when we go back to the map, we're going to see that when we come down here also. So you can see this is the fence, this is the building, right? So if we just go a little bit further down, we turn around, we look at it, this is going to be the same lit up sign. This is going to be the same dark windows, the same fence here. You can't see any of this stuff in the background because it's too dark. But this is the area where this all took place. He didn't make it very far. He made it just about 2 blocks away. He was coming from this parking lot here with the auto zone or the auto repair center at this location. And then he runs up the street and he's basically stopped and tackled right here. So he doesn't even really make it a full 2 blocks before the whole situation gets even worse than it already was. So from my perspective, just on that analysis, it seems sort of a lot more analogous to one continuous event, right? This all happened connected. So it's going to be difficult in my mind for the prosecutor to break these things up or to say that they're 2 separate incidents, right? And that's important for the analysis, because if somebody's withdrawing or somebody's fleeing or if he's re-engaging in something, then this could be considered 2 separate offenses. This could be something where the threat ended and then it began, or it never existed to begin with. So timing is pretty important. I don't think it's going to be an issue. I don't think that changes any of the analysis that we talked about yesterday. It's just confirming that this was all kind of one long thing. The first shooting took place. He was immediately being chased. He ran up the street, and he basically never disengaged from this altercation. So it all happened very, very quickly, and it looks like he was running away from the original incident, which of course we saw in the videos. So the big question that were left with yesterday, we analyzed the second part of the shooting, which again, we just saw the map. So it's really one big shooting, but I'm still going to call it the second part of this thing. When we were discussing that, it was pretty clear that seemed to be just bona fide self-defense, not even something that you could really question, because there were other people who were actually swinging and hitting at him, and it did look like he was under duress. It looked like he was under a threat. So if that is the situation, what we were really concerned about was, okay, the second part of the case is all dealt with. We have pretty good evidence that it's pretty clear that it looks like self-defense to us. The second part of the equation, which is really the first part, is what happened during the first shooting. Who shot first? Why was he firing his weapon? Was he being chased by somebody? Was he provoking somebody? What was this interaction that was taking place? And because we didn't really have anything to analyze at that point, just a grainy video and somebody who got shot in a body on the ground, that was kind of an open question. But we still reached a conclusion based on what we had at the time. But fortunately now we have some new evidence. So a lot of this video comes from the New York Times. It's from somebody else who recorded the video, but the New York Times actually broke it up, and so they circled some key bits and pieces that we're going to dive into. They circled where our attention should be, which was great, but I'm sort of piggybacking and adding on top of that. So I downloaded the videos, made some recordings of the videos, and then put them into some software that we use for video production here called Adobe Premiere. And what you see here, this is the actual video footage, and this is the audio profile that matches the video. So as we scrub through this, as we roll around it within this, we're going to see that we can hear a lot of what is exactly what we're seeing. And if you look on this little box down here at the bottom right, which is where my current face is, so let me go ahead and move that. You're gonna be able to see that this is something where you can actually see the audio spikes. So let me move that out of the way. And we're going to see these spikes as we start scrubbing through this. So when you zoom in, you're going to hear that these big spikes are these pops. So as we scrub to the left, and the audio is going to be loud, you're going to have to deal with it. We're listening to gunshots. But this is the part here where you can see the red kind of spike up. So there it is. Those are gunshots. So let's listen to it quickly first, and watch what the New York Times is doing to show us where we should be focusing our attention. So very briefly, you're going to see, boom, see the handgun muzzle flash. So what they do, and then you hear the audio. So what they're doing is when we back up, they're going to show you where it is. Now watch this spike down here. Let's zoom in so we can see these spikes very clearly. And you're going to see that the sound of the gunshot starts right here. You can see that spike. Okay, so the gunshot is tied to this right here. It starts here. They pause the sound so that they can put this animation in, and then the gunshot picks right up. So to me, that looks absolutely like a gunshot. Now, we didn't see that or hear that because the video was so fast and we just didn't catch it at the time. But this looks like it was a gunshot. Now, this is not Kyle. Kyle is over here. Kyle is right here, and somebody behind him is actually firing a gun up in the air. So, boom, you pause it. Now, listen to the gunshot. There it is. So you can see right as that pop happens, the hand is kind of coming down. Okay, the pop is happening right there. Boom, and that is the muzzle flash. So that certainly looks like a gun to me. I mean, somebody is firing first based on this clip. Now we don't know what happened before this clip over in this area. Where this picks up. This is where it picks up. We don't know if there were other shots being fired prematurely, but this is Kyle. And as the video goes through, they're going to show you the muzzle flash. You're going to hear the pop. There it is. There's going to be that man who's chasing Rittenhouse, who's ultimately shot and killed. He's chasing Rittenhouse, who's going this direction. And let's listen for the other gunshots. So they're pausing to show you Rittenhouse again. Now get prepared because these are going to be the gunshots. We're going to see 3 successive gunshots back to back. Watch. Okay, so you saw that. You saw these spikes. You heard them. Those are the gunshots. So when we are now focused on the gunshots, the theory is we want to see, is there any indication that those spikes over here, those gunshots, are those coming from Rittenhouse? Where are those coming from? People are running away. Are we seeing any other muzzle flashes from him or his direction? We're just not. I'm not seeing anything in this general area. So pop, pop, pop. It's actually hard to see where that comes from. Then we're going to see some more pops. And let's see if we can pinpoint where this stuff is coming from. And we really just can't. Okay, now he's over here at that point in time. So presumably those shots were... Yeah, so something's happening back here. That man is obviously down now. So some of those shots were Rittenhouse's. It's hard to really determine whether it's all sort of 6 of them or whether it's this first batch or the second batch. I think it is all 6 of those. I think those were all coming from his firearm, but the video just doesn't show us much. We're sort of just presuming that that's happening. What we're hoping for is for something to match this first example, right? Where we can see a flash and we can match the flash to the noise. So we can say, okay, that is coming from somebody else that is firing, up into the air. But Rittenhouse, we just don't see the same evidence. Doesn't mean he didn't shoot. Doesn't mean that those are not his bullets being fired. Just means we can't see it. 1, 2, 3, 4. 1, 2, 3. Okay, so we got 7 shots there. You can see them. They match the spikes, and we just can't see. Now we know that he shot. I think it's Rosenbaum is his name, and he was shot and killed. And the rest of the video will follow up. It kind of zooms in, and it's not good. Obviously, anytime you're watching something like that, it's gruesome. It's terrible for the person. It's terrible for their family. So we're not going to spend a lot of time on it. Now, we don't see any other gunshots. We don't hear them throughout the rest of this. So they're going to show that Rittenhouse comes back around, and then he runs off. Now, this is where he's running. So if you remember, this is in the parking lot where, what did I do with the map? There it is. So this is in the parking lot down here. And so at this point in time, Rittenhouse is really standing in this direction right here. This is when he takes off going northbound, and then he gets sort of intercepted by the other people. Now this is, he takes off going, he runs off. Great. This next video is the same thing, but it's from a different angle. So remember now, so let's take a look here. So this is the auto shop, and that means this other person who's recording this video is essentially right here. So if that other person who fired the gun was right here, we should see it somewhere in this second video, you would imagine. and we actually do, in fact. So as this video goes through, we're going to see
Them is
some
white
pause.
boys.
So they're going to pause. They're going to show us Rittenhouse. We're going to see the man.
Yeah, that's Antifa, man.
Now, this is something that's been very interesting, too. He throws a bag. Now, I've seen a lot of stuff on Twitter saying that, you know, he didn't have a weapon. He was just throwing a bag. This was just an empty plastic bag. There was nothing in there. There was a lot of speculation that he was throwing a Molotov cocktail. There was a lot of thoughts that this was, you know, an actual weapon of some sort, just because people saw the action of somebody throwing something. They thought it was a Molotov cocktail. Well, it turns out there's other photos. I've clipped a lot of them that show that this was actually just a plastic bag. But if you watch this, it looks to me like there is a brick or something heavy in this bag, because you can't throw a plastic bag like that, right? You can't. I mean, a plastic bag is it's very light. It's just like throwing a piece of paper. You know, it just kind of will putter down to the ground. That's not what happens here. So this does look like, to me, like a weapon. So now we've got two people who are basically discharging weapons right around Kyle as he is running away. If that's not self-defense, I don't know what is. So the response to that argument is that he provoked them. He shouldn't have been there. He was underage with an illegal firearm. He was breaking the law. He was past curfew. All of that stuff. Everybody else was also doing that. There were many other people there who were, who had firearms. There were many other people who were there out past curfew. So, you got to make a judgment call on that, right? The cops were not enforcing any of those laws. Yes, technically they're illegal, but is that going to carry weight in this case? I think that the prosecutor is absolutely going to lean on that. They have to lean on that. As we went through the statutes yesterday, we spent a lot of time talking about those statutes, that if somebody is already in illegal violation of the law, they can't break the law and then claim self-defense. They can't they can't provoke somebody to hurt them, and then when they get hurt, claim, or respond to them being hurt with deadly force or with lethal force or with physical force, because they can't, start the fight and then respond to it and claim that they were just defending themselves. The law doesn't want to reward that. So as we're talking about this situation, we see that this gentleman is going to be throwing this object here, and watch it as it hits the ground. Tell me if it's a plastic bag. All right,
We got a good.
Little hard to see, but it does land and kind of slide around. It looks like there's a brick in there. So let's see if we hear any gunshots, and then we'll do a quick frame by frame.
We got a gun, baby.
Boom. There's the handgun. The same one that we saw in the other clip, right? This is going to be, so the other view, this guy is standing sort of right here in the parking lot. He's sort of right in this area, and the other view was coming from this angle, and we could see the gunshot on the left side of the screen, if you remember that. So that is the same handgun. Now it looks to me and it sounds to me like there is, that there is an actual gunshot. Let's hear it. There it is. So you heard the first pop right there. Watch the spike in the red. So you see that right there. Boom. That's the gunshot. New York Times is going to pause the video so that they can illustrate it, and then you're going to hear the rest of the gunshot pick up right there. Boom, there it is. So you heard that, and that initial shot is the one that we were concerned about. Who fired that first shot? So from my angle, from both of these video footage recordings, from the audio that we see, the sound matches the actual gunshot going off into the air, and you can also see that there is it's hard to tell what it is, whether it's fog or whether it's smoke. But you can see sort of right here that, it's a gunshot, it's a muzzle flash, it's kind of a no-brainer. Now, these are going to be the other spikes in the audio. These are the other gunshots that are taking place. All right, so now let's listen and let's look for those. Because on the first video, we couldn't see on this side of the vehicle to see what was going on here. Were other people firing at him or not? We couldn't really see. Let's see if we can see anything. All right, so those are the spikes. Those are the gunshots. So as we're scrubbing through, we can see the audio levels go way up on both sides. There's a gunshot that just happened. Are we seeing any muzzle shots or anything like that? The answer is no, I don't see anything. We're still clipping through. More gunshots. Camera's super jerky, so we just can't see anything. Now, Kyle is going to come around the corner here in a minute. you hear those additional gunshots take place that we saw from the first angle, and then this guy turns off into the woods because there's a gunshot. You know, there's bullets whizzing all around him. So we don't really learn much more from the rest of this clip. But again, the big issue, kind of the big takeaway, is that first shot. It looks like Kyle did not fire it from these two vantage points. Let's take a look at this other clip here. Let's see. All right, the parking lot view. And let's take a look at this clip. Let's go back over here. We saw this clip. This is going to be the second view. This is going to be the street view of the second shots. So this is when Kyle is running away now. Now, I think that this one is a lot less even debatable, but we can still run through the video and we can take a look at it and see what we can determine. So they're pausing it once again. Now watch. He's going to trip. And trip happens. Okay. So we're here. He starts pulling his weapon out. He's got a sling on his weapon, so when they try to pull it from him, they're not able to get it. And as these people are coming up, let's watch for the spikes in the audio. Boom. Boom. And boom. Okay, so there's Kyle. Here's another gentleman approaching him with a gun, a handgun now in his hands. So you've got another situation where he's being chased by at least 3 people. One of these guys tries to hit him with his skateboard right there. Okay, there's the skateboard. He's getting kind of cracked over the head with it there. This guy, who knows what he was going to do. So it's happening very quickly. And let's listen for the gunshots. Boom. So you could see all 3 of them right there. And 1, 2, 3. And then that clip is going to end, and you're going to see that he got hit with the skateboard, and he got hit with about to get shot, or potentially get shot from the actual gun that this person had here. So another review of that video. I mean, I think it just supports everything we spoke about yesterday. Looks like pretty clear self-defense from that angle as well. We've got some new information that that person had a gun. And when we go back to this last video, this is a good one that kind of shows both of them being combined. So let's see what we can tease out, if anything, from this final clip.
Hey, boys. Yeah, that's Antifa, man.
Throws that bag.
Oh, he got a gun, baby.
Shot. Boom.
They shoot him. Oh, he shot him. Get back.
Okay.
Shot him, man. He shot him. Shot him, man.
Yeah, so not much more that we're going to see out of that. He basically takes off after that point, and he is running away. I think this is going to be one of the most interesting legal cases probably of this year. I'm very curious to see what ends up happening with this, because there's very good arguments on both sides. From what I have gathered, it does sound like the prosecutor's office is going full force ahead with all of the charges. The criminal complaint is charging him with first-degree intentional homicide for the death of Anthony Huber, first-degree intentional homicide for Gage Grosskreutz, and then first-degree reckless homicide for the death of Joseph Rosenbaum. Also charged 2 counts recklessly endangering safety for shooting his AR-15 style rifle in a crowd and being in possession of a dangerous weapon by a person under the age of 18. So he's facing some pretty serious criminal charges. Now, I just don't know what they are going to end up doing with this. The prosecutor's office, this is one of those cases, because of the political nature of what we're looking at. They may just want to drive this thing home. They're going to say that this kid was He shouldn't have been there, too young, shouldn't have had a firearm. I understand those arguments, but I don't agree with them, right? We have a lot of 17-year-olds who are learned and trained on handling weapons. We have many of them who are in, ROTC, junior ROTC. They're going to be, after they graduate high school, they're going to be going into formal ROTC. Then they're going to be going into the military. We have people signing up for the military at the age of 18. So this guy is not far from that. We send them overseas to go, fight wars and to kill people. That's what they do. So the fact that he's 17, I don't think should disqualify him. Now, if it is something where there's according to the Wisconsin law, it does sound like it's illegal for him to even be in possession of this while he, while breaking curfew and all of those other things. Technically, that is, something that's going to cause problems with the statutes that we talked about. And, if you have not already seen that video, I'm not going to go through the statutes again because I spent about an hour doing it on the last video. So watch that if you haven't already seen it. Now, this is a case that I'm very excited to follow along. From what I can tell here, it looks pretty clear to me to be self-defense. But what is the prosecutor's office going to do with it? They're probably going to prosecute it. They're probably going to take it, fairly far. I am going to guess that they're going to try to plea him out, to negotiate a plea deal. But because he's got so much backing and because of the personality of this kid, he may want his day in court. He may have a lot of support around the country, particularly from people who are interested in, gun rights and the Second Amendment and the right to protect yourself, which, by the way, I agree with completely, right? What we're seeing happening around the country is not okay. If they're going to keep asking that we defund the police, there's going to be more of this stuff. There's going to be a lot more of this. And a quick reminder that I am a criminal defense attorney. My day job is to go against the police, but I still see that they have a valid function in society. Defunding the police, having more, armed militias of people who maybe are not necessarily best equipped to be protecting their property, but have no choice but to protect their property, is something we're going to see a lot more of. And you can't fault anybody for doing that. You can't fault people for protecting their property. Now, the counter to that, of course, is that Kyle wasn't even from that place. He traveled across state lines. He was sort of looking for a fight. I understand that argument, but I don't see anything wrong with wanting to help other people protect their property. We have a lot of people who contribute to causes and they join groups and they join, these different entities because it's important to them and it's important to us that we protect our property and we protect our livelihood. So you can't really fault him for, wanting to be a part of that. So that's why this is going to be so interesting, because the arguments go both ways. We're going to continue to follow this story. Based on the evidence that we're seeing today, it looks like self-defense to me. I think he's going to have a pretty strong case, but he's going to be fighting an uphill battle because the prosecutor's office has a lot of things that they can do just based on the fact that he was carrying a gun that apparently he shouldn't have been carrying. He was violating curfew. Those things I think are going to be used as trigger points that are going to justify them trying to get around the self-defense doctrine. They're going to say, yeah, it was self-defense, but you broke the law. Therefore, you can't invoke self-defense. You were instigating it. You were opening the door for this to happen by being there illegally, by being in possession of a gun illegally. Therefore, the self-defense rules just don't apply, and we're going to prosecute you to the fullest extent of the law. We're going to see how that works out for them. I do not think that this is a case that is going to go down quietly. There are a lot of issues here. It's a very interesting case because of just the nature of the facts. You have a young kid, you have a lot going on here. You've got multiple shooters, you've got instigation, you've got other people with firearms. This is like, not to make fun of or not to make light of a difficult situation, but this is the type of case that they would give you in law school. They would say these facts happened and analyze it. What do you think is going to happen one way or the other? And so those, they craft those problems to be very difficult to solve because they want to see how much they can tax your brain. This reminds me of a law school problem. This is not the situation like we saw in a regular criminal case where somebody's getting a DUI and they get pulled over and they get prosecuted. It's pretty, routine, more or less. This is something where there are amazing arguments from both sides, and it's going to be fun to follow along. From my perspective, it's not going to be fun for any of these people, and I'm not trying to make light of the situation. This is a tragedy, of course. anybody involved is going to have their lives ruined. Kyle's going to have his life ruined. The people who were shot and killed, their lives are ruined. Their families' lives are ruined. And this is just going to escalate things. We were already at a hot temperature. We were at like a level 8 in this country. It's going up. It's going to get warmer. I think we're going to see more of this stuff, unfortunately. And we're still 2 months out from an election. So this temperature is just going to keep going up and up and up and up and up. First and foremost, let's take a look at the actual header of the complaint. So when we're talking about the actual complaint itself, we can see here, this is what it looks like. State of Wisconsin versus Kyle H. Rittenhouse, filed on August 27, 2020 with the clerk of the circuit court in Kenosha County, Wisconsin. And it's going to be heard by the Honorable Bruce Schroeder. And so we want to talk a little bit about who that is, because a judge is very important in a case like this. A judge is going to be the person who is going to be ruling on the motions, right? So if you submit a motion to suppress evidence, for example, the judge is going to rule on that. Both sides are going to make their arguments, and then the judge is ultimately going to make the final decision on that. And so the judge can be instrumental in plea negotiations. They can handle settlement conferences. And so it's really important that we know who this person is, and we do now that the case has been filed and assigned. The gentleman who is going to be hearing the case is Judge Bruce Schroeder. And a little bit of information about Bruce Schroeder. Bruce Schroeder earned his undergraduate degree from Marquette University in 1967. 1970, he earned his JD from the same school. He was appointed to the bench by Governor Tony Earl, who is a Democrat, and that happened in 1983. So you can ask yourself whether or not that actually matters. The Democrats today, I'm sure, are very different than the Democrats in 1983, and so I don't really think you can read anything into that. What I do think is important is that it does sound like this judge was actually a former prosecutor. We see here that from 1971 to 1972, he was the assistant district attorney. From 1972 on to 1977, he was the actual district attorney, and then he went into private practice before becoming a judge. And this is the same sort of a formula that we see for a lot of prosecutors. They start off as prosecutors. They use that as sort of their calling card to then become a defense attorney. They always shout, "Yeah, I used to be a prosecutor, therefore I'm amazing somehow." And they become a defense attorney. I call them the non-true bloods. There are those of us who are true blood defense attorneys, but some of these prosecutors are not. They kind of flip sides a little bit. So I like to needle them from time to time. But this judge, he kind of did that, right? He was a prosecutor. Sounds like he went to the defense. I don't know that for sure because he stopped practicing in 1983. Then he became a judge, and he's been sitting on the bench ever since then. But what does that mean? Do we actually know anything about this judge? Not really. Obviously, I'm not licensed in Wisconsin. I don't know him personally, but I was able to find an article from the AP that was written in 2006 that is entitled "Hundreds Ask to Avoid Court of the Kenosha Judge." The reputation of one Kenosha County Circuit Judge is apparently so daunting that hundreds of defendants request a different judge, creating imbalances in the workloads of different felony courts. And of course, Judge doesn't know why. He doesn't know why as many as 250 people since August have requested that somebody else hear their cases. And, this is something that happens in Arizona. Happens all over the country, in basically any place that has the ability to file what's called a notice for a change of judge. If you're a criminal defendant, you have a right to just strike that judge. You ask for a different judge. It sort of helps eliminate bias or perceptions of bias, just to say, you just have a strike. You just get to, we're not going to even ask any questions, just file this notice and we'll change judge. So really that's what was happening with Judge Bruce Schroeder for some time. There was some speculation in the article as why did this happen. It says here that Schroeder is known for his occasional fiery style, sharp tongue, and stiff sentences. He can also be unpredictable, says defense attorney Michael Ciccinelli. From a defense standpoint, clients like somewhat more certainty. And another judge actually said, "I think Judge Schroeder is sometimes stern in his sentences, But he goes on to say the sentences are no longer on average no worse than any other judge. So that's what we know. Nothing really groundbreaking there, but it does help provide some context. This judge may be somebody who is, a little harsher on sentences than otherwise, because it sounds like defense attorneys have probably caught wind of what it's like to be a defense attorney in his courtroom, and they've been recommending to their clients, you got to change this judge, file a notice for a change of judge. Now that happened in 2006. It's ancient history, especially in today's world. So we don't know, if that has changed or if this is still something that is going on, but it does provide some historical context. So the first charge that we're going to see is the first-degree reckless homicide charge with the use of a dangerous weapon. And this goes over to this individual right here, Joseph Rosenbaum. So if you remember him, this was from this part of the interaction where Kyle Rittenhouse is actually being chased down by Joseph Rosenbaum. So this is him right here. This photograph comes from a different picture of the evening where he was basically getting in somebody else's face and saying, why don't you shoot me? You want to shoot somebody, shoot me type of language. That was earlier in the evening. And then, essentially he was being provocative. From what we were able to see, this is a mugshot that I was able to find from him. Don't have any other, sort of flattering pictures that I was able to come across. Otherwise, I would have included one just for the sake of balance. But we have a mugshot, and then we have a picture from him earlier in the night, and then we see him here sort of being chased away. So they're saying that Kyle actually did recklessly cause the death of him under the circumstances, showing an utter disregard for human life, contrary to the statutes. Now, I'm not going to spend a lot of time on the statutes today on this show. I spent a long time yesterday or in the previous video really detailing the statutes, spent about 45 minutes going through every single one of them. So we're not going to do that again. I'm going to presume that you watched that video. You're up to speed on that. And so we're just going to read the complaint and the probable cause statement because, like I said, this is something that is written, in my opinion, so kind of one-sided that there's only really one logical conclusion that we can come to, and we will get there. So that was count one. Count one goes, it's basically the victim of that count is Joseph Rosenbaum, which is this individual right here. All right. So we have him here. Count number two, complaint number two, is going to involve the chief video director for the Daily Caller. This is Richard McGinnis. This is his photograph right here from his Twitter account. If you want to follow him, I actually have his Twitter handle later in the presentation here today, and so you can follow him if you'd like. But he is the victim of a first-degree recklessly endangering the safety, his safety, and we're going to dive into why they included him on this complaint. Why is he the victim of a crime? He wasn't actually shot or anything. If you remember, this is him. When Rosenbaum was shot, McGinnis actually goes over there and takes his shirt off, and he's trying to heal, or kind of nurture or save him, help him with his wounds. And why is there we go. He's trying to help him with the bullet wounds. Now, we're going to learn later that he was shot multiple times, and sort of the efforts of McGinnis don't really do much of anything. He shot multiple times, so he was going to die. But he is the stated victim of this crime, and so it's important to recognize that.